All right, Ms. Clark, you have a stipulation to offer at this time?
I do, Your Honor.
All right, would you read that slowly, clearly, so the jurors
Yes.
can hear it? All right.
Read it to the jurors.
Thank you.
It is hereby stipulated that the following cellular telephone records, which include records that have been marked as exhibits in this case, were prepared in the normal and regular course of business at or around the time of the information contained within the records, and that the records accurately reflect the information contained therein. And that is for the following records. The cellular telephone records for the date of June the 12th, 1994, for the cellular telephone located within the Town and Country limousine driven by Allen Park on June the 12th, 1994. The cellular telephone records for the dates of June the 12th and June the 13th, 1994, for the cellular telephone belonging to the defendant, Orenthal James Simpson, and the cellular telephone records for the date of June the 13th, for the cellular telephone belonging to Detective Ron Phillips.
All right, Mr. Cochran, is that stipulation acceptable to the defense?
Yes, so stipulated, Your Honor.
All right, then the stipulation is accepted by the court. Ladies and gentlemen, a stipulation is an agreement between the attorneys as to certain facts, and you were to accept those facts as true for the purposes of this trial. All right, counsel, at this point I'm going to take a brief recess, and I'd like to confer with counsel in chambers with the court reporter, please. All right, ladies and gentlemen, we're going to take a recess at this time. Please remember my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Do not conduct any deliberations, and do not allow anybody to communicate with you regarding the case. And we'll see you back shortly. All right?
Well, for every document, there has to be some measure of authenticity attached to it. You have to, with the cell phone records, essentially put somebody on the witness stand to say, yes, this is how our records are kept. This is how we develop these cell phone records and the dates and times. It's done quite often by computer. And so it would really be fairly pro forma. And instead of wasting the court's time and the energy of bringing a witness inside the courtroom, they agree to it, the stipulation. And it's fairly common, isn't it, Elizabeth Semmel?
Certainly with records like this, both sides would have had an opportunity to probably check the records out themselves, speak with company employees and determine how the records were prepared and satisfy themselves that the normal operation or procedure had been followed, and really eliminate the need for someone to testify to what may be obvious and, most important, not in dispute as far as the preparation of the records.
Yeah, cell phone records, telephone records of any kind are generally pretty reliable, though computers are not always perfect. In fact, we saw it just yesterday afternoon with James Williams, the SkyCap operator, who said, look, all I do is punch in some facts and figures into our computer, and out pops the ticket that demonstrates where the luggage is to go from, where it originates, and to its destination, and also the time and date, and of course the date was wrong on the computer. That O.J. Simpson had left from LAX to Chicago, the O'Hare Airport, on the 12th, close to midnight, and the ticket reflected the 13th, and of course that would have been impossible. He was in Los Angeles, and everybody was watching him in Los Angeles.
Well, I'm making an assumption that both sides have done their homework, and by that I mean before entering into the stipulation, they've both done whatever investigation they need to satisfy themselves that the computers were working or whatever procedure was indeed followed.
Now let's talk for a moment about the witness who was on the stand, Sue Silva. She identified the perimeter alarm system that has contacts on exterior doors, a beam in the foyer. And all of that may prove absolutely nothing if you take the defense position that he was at home, so no need to set the alarm. And number two, in a way, if you want to take the prosecution's theory that, look, this is a guy who went out to commit 2 murders quickly and would not have set the alarm because he wanted to get back into the home unseen, and you know it would be time consuming to punch in the alarm. And the real point on that is that West Tech is never notified whenever the alarm system is activated as on, as it's only an intrusive alarm system, so they only know about it when it's broken.
Right, so it may be much ado about nothing, it may be a non-issue. Alternatively, even adopting the prosecution's theory, if Mr. Simpson had come home, he certainly had the knowledge or the ability to turn the alarm system off before entering the house so it wouldn't be set off. So it may be that the prosecution was simply trying to eliminate speculation about an issue, or alternatively the defense as well. It may turn out to be, as I said, much ado about nothing.
Yeah. Well, when we come back, a new attorney on the case, Sean Chapman. She has, of course, been in this case long before this, but we saw her today for the very first time asking questions. We'll tell you a little bit about her when we come back. Welcome back. The court was delayed this morning, as it often is, but once they did get underway, a brief witness, Sue Silva, a West Tech employee. West Tech is the alarm system that O.J. Simpson had installed at his home and was operable, apparently, though it may not have been turned on. We just don't know because it wasn't that kind of a system that alerts West Tech whenever it is turned on, only when it is breached. Let's go to Kristen Jeanette Myers. And what was the intention, Kristen, of prosecutors by presenting this witness?
Greg, I think the point is that the defense wants it to be that the alarm system was off that night before O.J. Simpson left, and the prosecution wants to say it was on. And here's why. The prosecution needs to explain why it is O.J. Simpson would be back in that small alleyway where the air conditioner is behind Cato Kalin's room, dropping the glove, and why it is he wouldn't just enter his home through the garage door or the laundry door, why he would walk out into the driveway area to be seen by Alan Park as a 6-foot 200-pound African-American was. Why wouldn't he just let himself in if he was trying to sneak into the house? Or alternatively, why wouldn't he go down around the guest houses, circle through, and come in the back of his own home? If he was really trying to get rid of clothes and sneak into his house, then why would he walk right in front of everyone across the driveway and in the front door? Well, if the alarm was on, the prosecution says, he didn't have the option of going in through the garage door, the laundry door, or any of the back doors. And so he was stuck, and he was forced to walk quickly, according to the prosecution, out from behind that garage area where the glove was found, straight across the driveway and into the front entrance of the house, the one entrance that he had a key to, and a key that would deactivate the alarm system. Of course, the defense wants to say the alarm wasn't on, so he could have done all those things, so the prosecution's theory doesn't make sense.
Does the prosecution have a theory as to why in the world he would set the alarm to go out and kill 2 people or 1 person?
An excellent point. Not that I know of, and at the time right now trying to think of what an explanation could be. Maybe it will be their position that it was his custom and habit to have the alarm system on and that he did it as he left, and therefore it was on. But I think that's a very good point, and I think that that's what the defense will say in addition. But the problem with the prosecution's theory is they've got to explain first why O.J. Simpson would be back in that alleyway bumping into things and dropping a glove. And second, if he was, why he wouldn't just go back into his home through the doors on the side of the house or the back of the house, why he would walk in front of the waiting limousine in the line of sight of Allen Park. It doesn't make sense. The prosecution's got to explain it, and so in an effort to explain it, I believe they're trying to say he couldn't go in that way because he would have set off the alarms.
Chris Darden made reference to a new witness. Dan Abrams told us about it in the transcript of the sidebar conference. What more do we know?
I think that that's probably what's being discussed back in chambers right now, because the prosecution revealed in a sidebar conference yesterday that they have a new witness who says that he saw O.J. Simpson at the airport that night, leaning up and bending down and getting back up and zipping and unzipping a bag, presumably while he's by that trash can there was so much discussion about yesterday. Now, if that's true, and they also said the defense hadn't received any discovery on this witness, well, we can presume that the defense is back in chambers saying, we've been sandbagged, this is preposterous, we haven't had time to investigate this witness, and there is no way the prosecution should be allowed to put this witness on the stand. I think the defense further point is going to be that the credibility of this person is going to be very small, because if they didn't come forward till this point, well, how in the world can anyone believe such a witness who suddenly remembers that he saw O.J. Simpson bending sitting down and unzipping bags at the airport on June 12th in 1994. I think that's probably what's going on in chambers right now, and it's an important decision the judge has to make. Are we going to hear from this next prosecution witness, or are the jurors through with hearing witnesses for the day?
Well, you know, both sides have sprung new witnesses on each other, and they always argue against it, and I suppose they could just replay each other's arguments to the judge. Let's go to Sean Chapman. We've seen her quite a bit inside the courtroom, really from the very beginning. But am I correct, this was the first time that she questioned a witness?
Yes, it was. Sean Chapman did participate a bit during the jury voir dire questioning. In jury selection, they let her handle a couple of the prospective jurors. Other than that, we haven't seen her handling witnesses. And I think that you could tell it was kind of a special occasion for a lot of people on the defense team. Johnny Cochran appeared to me to be beaming while she was giving her argument. He patted her, congratulated her afterwards. F. Lee Bailey also eventually leaned over and had some apparent words of encouragement. Sean Chapman, though, as you say, has been on the team from the beginning. Let's take a closer look at Sean Chapman.
People talk about how many lawyers there are in this case. There's not nearly enough lawyers on this case for all the work.
Attorney Sean Chapman is one of the more than 12 lawyers hired by O.J. Simpson to handle different aspects of his case. Chapman is an associate at the law firm of Johnny Cochran, one of 2 associates chosen for this high-profile assignment.
When he first said that he was going to take the O.J. Simpson case and told me that I would be involved, I thought that I was going to be in the library day and night researching issues and handing him memos on the research that I'd done and basically just hid away somewhere. And instead, he has me in court with him. He has me at every major meeting. He respects what I have to say.
If Chapman sounds incredulous, it may be because of the company she's keeping. O.J. Simpson has assembled a team of high-powered and accomplished lawyers. And because of her association with Johnny Cochran, 32-year-old Sean Chapman is on the team. Chapman's duties range from research and courtroom support to taking statements from Simpson in jail to help prepare the defense. Chapman graduated from the Southwestern University School of Law in Los Angeles in 1988. She worked as a public defender in Los Angeles for 5 years before joining Cochran's firm in January of 1994.
I was a public defender downtown Los Angeles, carrying a very heavy felony caseload, and it was a major decision to leave, and I made the right decision. No question about that. Timing's everything.
And now Sean Chapman can add to her list of duties, cross-examining a witness in the O.J. Simpson trial.
Absolutely. Kristen, let me ask you to stand by here for just a moment as we bring Elizabeth Semmel back into this conversation. Didn't mean to ignore you for a while. This new witness sprung on one side here at the 11th hour. What's the law on doing that?
Well, there's nothing that precludes the prosecution or either side from calling a witness when they would argue or contend that that witness just came to their attention. In other words, the rules of reciprocal discovery don't require disclosure of information before you have it. On the other hand, it may very well be that Judge Ito will give the defense the opportunity to investigate the background of that witness or the circumstances under which the statement was made before permitting the prosecution to call the witness.
So just as the defense came up with some new witnesses at the 11th hour, their duty is to immediately disclose it to the other side, and once they've done that, they've satisfied the law. Then the question is, when is the witness called, and that's really in the discretion of the judge.
Right, and of course the question may be raised by the defense as to when the prosecution really knew about this witness. In other words, is the prosecution being forthcoming and truthful in saying that the information was just provided? What if it came last week and the information is just being disclosed today, for example? Obviously, those are questions to which we don't yet know the answers.
All right, well, this trial has several stages to it, several phases. We went through the first phase, which is yet to be completed, quite honestly, and that is the domestic abuse allegations leveled against O.J. Simpson, that this is part of a general plan and motive and pattern of conduct, abusing his wife that ended in the ultimate act of abuse, say prosecutors, murder. Several witnesses have testified to that. More will testify at the end of the case. And then they shifted to the murder scene, and they presented lots of witnesses, most of them police officers who were there, who collected the evidence. at the murder scene and supervised its collection. Still more criminalists will be taking the stand shortly. And then to O.J. Simpson's property, what Alan Park, the limo driver, saw, Cato Kalin, his observations there as well. And now we move into the phase of the physical evidence, its collection and analysis, its testing. And Kristen Jeanette Myers, back to you on that. Today, the judge will be listening to somewhat arid arguments on DNA. What will happen?
And it could come more quickly than we had thought, because if this witness doesn't testify, we already know Robert Kardashian's not going to be heard today. And so when that is completed, we're going on to DNA. What is first being discussed is this issue of whether the defense can raise admissibility questions about the DNA evidence. Now, you might think, I thought they waived those back on January 4th when they said, we don't want to have a so-called Kelly Fry hearing. We waive the issue of whether DNA is admissible. Come on, admit it, bring it in, and what we're going to do is challenge how the tests were done and whether the results are correct. Well, now the defense is saying, actually, we only waived the DNA tests that had been done up until that point, January 4th. And any testing done afterwards, we didn't waive admissibility, and now we want to challenge whether it's even admissible, whether the jurors should even hear about it, and not even get to the part about where we argue about whether the tests were done right. What's significant is one of the most important tests that was not done on January 4th, but is completed now, is the testing on the blood found on the rear gate at the Bundy crime scene. And prosecutors have said in open court, DNA tests show that that blood is the blood of O.J. Simpson.
Well, Kristen, why would they change tactics here if in the beginning they're willing to admit that it's acceptable in court as a general scientific principle? Why now wouldn't the same reasoning apply to that testing, which was done after the waiver?
Good point, and that's what the prosecution is arguing. The defense, this may not be a switch so much as what they were planning all along and the prosecution was afraid of. Remember back in December, the first plan the defense floated was, let's just go to trial and have the Kelly Fry admissibility hearing in the middle of the jury trial. They really wanted to get on with the show. Well, the judge rejected that, and the next thing the defense offered was, well, okay, then we waive the Kelly Fry admissibility hearing. But at the time, the prosecution was very concerned that this was a true and complete waiver, and they even asked that O.J. Simpson himself acknowledge in court, which he did, that it was. But now we're seeing, perhaps, what was intended or contemplated all along, that the defense really did not want to let go of that issue. They wanted the trial to start, but they also want to be able to fight the DNA issue on any front they can, and they've seen an opening here.
So if I understand you correctly, their motive was, let's get the show on the road, and now that the show's on the road, let's stop the show for a while and do what we had originally wanted to do. But of course, they're limited now, arguably, to that which was discovered and tested after the after the waiver.
True enough, but it does certainly throw a monkey wrench into the prosecution's case if there is an interruption of a number of weeks to have a Kelly Fry hearing, even if it's only on the evidence after January 4th. I do think, though, it's unlikely that Judge Ito will grant this, and it will probably be the case that O.J. Simpson's waiver is found to be valid, and unless there were new testing procedures employed after January 4th, I think he's going to be stuck with what he agreed to. And our understanding is the tests that were done on different pieces of evidence after January 4th that had not previously been tested, well, the tests were the same RFLP and PCR tests that had been waived by the defendant O.J. Simpson on January 4th.
Yeah, so the fact that these tests are basically the same kinds of tests that were done before the waiver now sort of bootstraps the waiver to subsequent tests.
Well, I think so, exactly, because it wasn't the results that the defense was waiving on January 4th. They were never waiving the results. They always said, of course, we're going to argue to the jury that the results are incorrect. The issue was admissibility of these types of tests, and they waived it, and irrespective of the particular results, and that's what the prosecution's going to say. And I do think that is what the judge is likely to conclude.
Well, let's bring a criminal defense lawyer into this before we take a quick break here. And Elizabeth Semmel, That's going to be a tough argument for the defense, won't it?
It's a tough argument, but let's remember that one of the unusual things about this trial is that typically all of the testing is done by both sides before the trial commences. It's rather unusual to have this amount of evidence tested as the trial is going on and this amount of uncertainty as to the results as the trial is progressing. And I'm not so sure that it wouldn't have been questionable if the defense, in light of these new results, hadn't reasserted the issue. I think they may have a duty, in light of the change of circumstances in the new results, to raise the issue again.
Yeah, and the law keeps changing almost on a daily basis here in California. The Supreme Court here has depublicized, decertified, I guess, some of the earlier opinions in the lower courts because they're now considering the DNA issue. Though I have to say, just as they did that, then the First District Court of Appeals, I think, here in Southern California, issued a new ruling on DNA, so that seems to be after the depublishing by the Supreme Court. It's a little bit complicated. So that now is the prevailing law, the Court of Appeals, which accepts DNA evidence. So just as prosecutors were about to lose firm footing, they gained it in a day.
Right, although certainly one could say that the law is in enough of a state of flux that firm footing may be too strong a statement to make. Certainly the trend is toward acceptance, but there's obviously a lot of issues that have yet to be resolved.
Yeah, they're sort of standing on Malibu soil. We'll be back in just a moment with more of our live coverage. Welcome back. We're live in Los Angeles. Nothing happening in the courtroom right now. The judge did declare a recess, and he's beyond the limits of it, but that often happens as well. They may be discussing their next move. Should a newly disclosed witness take the stand now or later, if at all? And second, when should we begin arguing the issues of DNA evidence? Because this case has now shifted into a different phase. The collection of evidence, the preservation of it, and the testing of blood evidence. And all of it has to do with a fairly complicated and sometimes cryptic term DNA, which stands for deoxyribonucleic acid, and that's about all I remember from biology. June Grasso knows a bit more. She prepared a background report on it.
No two people except identical twins have the same genetic material or DNA. But what is DNA? The letters stand for deoxyribonucleic acid.
DNA is the blueprint molecule, the chemically coded information that carries a person's hereditary information, what they are, what they look like, their individuality.
More than 99% of the DNA is the same for everyone. But there are areas between the genes called polymorphic regions. The DNA patterns of these regions vary dramatically between individuals. These are the areas that are tested. There are two basic kinds of DNA tests.
PCR, 3 letters that stand for polymerase chain reaction. Big word, pretty easy. It's a copying process where a relatively small piece of DNA is copied multiple times, tens of millions of times. RFLP, restriction fragment length polymorphism analysis, is done with special enzymes that act like molecular scissors. They will clip out, if you like, a piece of DNA that we're interested in so that we can then analyze it.
PCR takes less than 2 weeks, provides less information than RFLP, and is often used to eliminate a suspect rather than to convict. RFLP takes up to 12 weeks, requires a larger sample, and is more definitive. But how definitive is it? And is it fair to the defendant? But remember, our criminal justice system isn't based on 100% certainty. It's based on proof beyond a reasonable doubt. Judge Gerald Scheindlin, acting justice of the Supreme Court in Bronx County, New York.
The standard of proof in all criminal cases is proof of guilt beyond a reasonable doubt. It is not proof that requires absolute certainty, mathematical certainty, beyond a shadow of a doubt, or even scientific certainty. It is, however, the highest standard of proof known to the law. There is no higher standard.
It's rare that DNA matching evidence is all the prosecution has.
There aren't 500 or 1,000 or 300,000 suspects who are logical, who are involved in the case. There simply are not in any given case. There were only a few people. So it's very easy, if you have a 1 in 100,000 probability of match, to tell apart 2 or 3 people. And only one is probably the one, and the other 2 or 3 will be eliminated.
It does not seem possible that someone could be convicted merely on DNA evidence, as it is not possible for someone to be convicted merely on a fingerprint.
What was in dish number 6?
Dr. Robert Genslin, professor and director of the Forensic Science Program at the University of New Haven in Connecticut, compares fingerprinting to DNA testing.
Identical twins have different classical fingerprints, but they have identical DNA. So right there's a difference.
So can you really compare DNA testing to fingerprint analysis?
You have to compare one fingerprint to another, and then to another, and then to another. In the DNA world, you can make calculations because DNA follows genetic rules that we're very familiar with. And so you can use that as a basis for making calculations. You do not have to compare everyone on Earth's DNA.
Fingerprinting has been around for nearly a century and is virtually the definitive means of classifying and identifying people. But its uses are limited. DNA testing not only helps identify criminal suspects, it was used in the Persian Gulf War to identify the American war dead and is used to detect genetic disease. In fact, it's changed the way we think about diagnostic medicine.
I assure you that it is not voodoo science. It is hard, reliable science. The issue is twofold. Number one, are you doing the testing correctly? And number two, how do you interpret the result? It is a science that is so fascinating that it almost allows you to peek into the 21st century.
Is DNA testing as foolproof as fingerprinting? Is it indeed genetic fingerprinting? On both questions, the jury is still out. June Grosso, Court TV.
Well, whether or not it's reliable, let's set that aside for the moment. The defense has to fight against something else, and that's sort of the image of DNA. DNA associates with itself science and statistics, probability. And math and science, Elizabeth Semmel, are considered by almost everybody to be precise and accurate. I mean, that's how we're sort of brought up. Numbers are numbers, and you can't much play with them. And science we consider to be pretty reliable and precise. So that's something that prosecutors have going for them, isn't it?
They have that going for them, and I think they have the fact that many people are intimidated by numbers and people who understand numbers.
Right.
And when a scientist comes in and talks in numbers, the process of determining those numbers seems beyond the ken and the understanding of most individuals, has an aura of reliability, which I think the defense will have to work to undermine.
The great value, I mean, you could have wonderful physical, scientific, mathematical evidence, but if you don't have a good presenter of the evidence, you may lose out completely. So these prosecutors have to have somebody, and they believe they do, who can present it in a very authoritative, professorial way, a way that will make these jurors want to listen and understand and believe.
Right, and also not alienate them. In other words, the witness needs to be intelligible to the jury, not make the jury feel they're being condescended to. So authoritative, but not authoritarian. But there are a number of areas that the defense has to go after in undermining the reliability of DNA evidence.
For example?
Well, we've started with some of them beginning at the inception of the case. First of all, there are certain types of evidence that are easier to test, or testing about which is more reliable than others. So it depends on whether we're talking about the gait, the bronco, the glove, the socks, etc. Then the method in which the evidence was collected, the method in which it was preserved. We have the whole issue, as I recall, of Van Adder taking the blood, holding on to it for a period of time rather than preserving it in a refrigerator at the police department. We have the method by which the laboratory works. What are the procedures within the laboratory? What is the training and experience of the individuals who did the testing? The reliability of the individual testing methods, and then remember, of course, DNA is a process of interpreting results. And then, lastly, and perhaps most importantly, we can come up with numbers but what is the statistical significance of those numbers? What do they really mean?
Have you ever tried a DNA case?
No, I haven't.
So
I've been fortunate enough to avoid DNA cases.
Yeah, and you've been practicing about 20 years.
I
so
have.
I guess
I have.
The point is that it doesn't happen all that often. I think we added up the number of cases in California in which DNA has been used over the years. It exceeds somewhere in the neighborhood of 70, and when you consider the total number of cases that are tried each year, it's a very small percentage.
But it's certainly fair to say that it is a coming thing and that it is something that defense lawyers and prosecutors need to learn. The reality is that it so far has been limited enough that there are really a handful of lawyers on both sides who've developed a great expertise in the area, and the rest of us who have a lot of general knowledge, which is probably a dangerous thing.
One of the real difficulties for the defense is the following argument. Some contamination may have occurred with some of the evidence, the blood evidence. But nevertheless, if we run 70 different tests with a wide variety of markers and they all come up with the same result, the contamination of 2 or 4 or 8 of them wouldn't cause the same inclusion of O.J. Simpson. I mean, contamination renders it meaningless, if I understand the science.
No, contamination could distort the results. It seems to me that there may very well be an argument that it isn't just a question of saying a contamination could produce an inconclusive result,
right,
but contamination also may produce an inaccurate result, and there's a distinction there.
And an inaccurate result which would identify O.J. Simpson's
Well,
blood?
that's certainly going to be, whether we're talking about O.J. Simpson or one of the 2 decedents, that may be part of the argument. Again, I think it's important to remember, of course, that the defense burden is, of course, that they haven't got one, but the thrust and the responsibility of the defense is to create doubt and to undermine the certainty that jurors may give to this type of evidence.
All right. We do want to report to you the latest information, and that is that at 4:30 Eastern Time, 1:30 Pacific Time, Judge Lancito will reconvene court to listen to these DNA arguments by the defense. And, of course, we heard some of it yesterday. Barry Scheck, the attorney for O.J. Simpson, who leads the team on DNA, along with his partner Peter Neufeld, they will now be doing the listening, most of it, today as prosecutors respond to it. Again, that's at 1:30 Pacific, 4:30 Eastern Time. In the meantime, the judge has recessed until then. So we're going to break away. We'll be right back with more of our live coverage.
Court TV is proud to welcome the following new cable systems: Bresnan Communications of Marquette, Michigan, Bresnan Communications of Marshall, Minnesota, and Bresnan Communications of Gwynn, Michigan.
Hello, I'm Dan Broden with the Court TV News Break. A Brooklyn federal judge has ruled that the military's don't ask, don't tell policy for gays in the military violates the First and Fifth Amendments. Judge Eugene Nickerson called the rules imposed by President Clinton and Congress last year, quote, a discriminatory policy. The lawsuit was brought by the ACLU and Lambda Legal Defense and Education Fund. The Central Intelligence Agency says it will pay over $1 million in back pay and salary increases to settle charges of sex discrimination. Class action suit was filed by female caseworkers in the agency's Directorate of Operations, which conducts undercover assignments around the world. Several hundred women had joined the suit between 1986 and 1994. And a federal judge in Pennsylvania has ordered the state to comply with a new national motor voter registration law. It is the third court victory in the Justice Department's attempt to force states to comply with that motor voter law. Judges have recently ruled against both California and Illinois. The law was passed by Congress 2 years ago, requiring states to register voters by mail at state offices that provided driver's licenses, welfare, and other services. That's the Court TV News. I'm Dan Broden.
Welcome back. We're live in Los Angeles. If you missed this morning's session, and you could have if you blinked, it was so brief, a West Tech security employee took the witness stand to say, essentially, here's how O.J. Simpson's alarm system worked. But it was very brief testimony, and it may prove in the end inconsequential. It may prove important to the prosecution's theory of why O.J. Simpson did what he did, returning to his home under the prosecution's theory. Then we expected either Robert Kardashian or a new witness to take the stand. But that won't happen. Let's go to Kristen Jeanette Myers. And Kristen, why not?
The jury has been sent home. There will be no more witnesses today, and we won't even have action in court until 1:30 Pacific time, when the DNA hearing will resume. What has happened is that the prosecution had decided that they would finish with this group of witnesses that they've been putting on, this idea of putting on the officers and the people who would testify to the timing and the crime scene and what was found that night and the Rockingham scene, all of the witnesses we've been hearing since the domestic violence testimony. Well, we're about to move into a new phase of the trial, and that is the collection and testing of evidence. Before that new phase, this DNA hearing has to be held. And we found out this morning that we are at the end of the prosecution's previous phase, whether they like it or not. They had intended to call Robert Kardashian and this new witness who alleges that he saw O.J. Simpson doing things with a bag by the trash can at the airport that night. But it appears that the prosecution is not going to be allowed to call that witness at this point in time. The defense, it is likely the judge has decided, has not had enough time to prepare for this witness. Although we don't know for sure what the reasoning is, we know that at this time that witness will not be presented. Also, we know Robert Kardashian will not be presented by the prosecution at this time. And again, that is because there will be an opportunity given to his lawyer to make arguments about why attorney-client privilege should apply between Robert Kardashian and O.J. Simpson. And so it will be at least next Wednesday, April 5th, before we even hear about the possibility of Robert Kardashian giving any testimony. Because of all this, prosecution's out of witnesses, and they're ready to move on to the collection and testing of evidence phase. Therefore, it's time for the DNA hearings.
Well, while we're on the subject of DNA, let's talk about one of the most important witnesses for the defense in DNA. And I suppose some background to add to it is that some key important defense witnesses seem to be, to some extent, disintegrating. There was great drama and flourish as Johnny Cochran during the opening statement revealed a couple of important witnesses, Rosa Lopez and Marianne Gertjes. Well, Gertjes has been taken off the defense witness list now, and Rosa Lopez seemed to disintegrate somewhat in front of the eyes of these defense lawyers while she was being questioned outside the presence of the jury. Kathleen Bell, another important witness, they may back off her just a bit. Max Cordoba, another defense witness who now is speaking in terms of dreams that prompted his memory. He too may be shoved off the witness list. And now we've understood overnight that one of the most important DNA forensic experts, Ed Blake, who signed up from the very beginning with the defense team with great fanfare. We have Dr. Henry Lee and we have Dr. Ed Blake, they said. Now Blake seems to be removed as a witness for the defense. Why?
You know, though, this actually could be something positive for the defense, because the fact is, if Dr. Ed Blake were to testify at this trial, he'd likely say that all of the testing he observed up at the Department of Justice that was done correctly and was done as the testing is usually done. And furthermore, he's a proponent, a supporter of the PCR testing that the defense says is at issue in this case. Remember back in the fall, the prosecution tried to subpoena Dr. Ed Blake and say, we want to call him. We want to ask him what he thinks about DNA, because he usually is a prosecution witness. Well, the defense fought the subpoena. They said, hey, he's a defense expert, and the defense won. But at the time, the prosecution made the allegation that the defense hired Ed Blake for, among other reasons, the desire to prevent him from ever testifying in the trial. And at the time, a number of commentators said, I bet you we'll never see Ed Blake. It turns out that that is going to be true. The defense is not going to call this man who, before he joined the Simpson defense team, was a leading advocate of the validity of PCR testing. Instead, what the defense has done, and there's nothing wrong with this, is hired one of the foremost experts to oversee the testing that has gone on for the defense, and if anything did go wrong, he would be there to identify it and report to the defense about it. But because it appears nothing did go wrong, they're under no obligation to call him and support the prosecution's case, and they are not going to. I think that taking him off the witness list, though, had to do specifically with the judge's recent push to get the defense to turn over any reports by any experts who have been utilized by the defense. And Ed Blake has no doubt made notes and may be making final reports, and so if he's on the witness list, those reports will have to be turned over. By taking him off, since they probably never intended to call him anyway, they will be under no obligation to turn over any reports that he might do to assist the defense in fighting the prosecution DNA evidence that's coming right up now.
Absolutely. And we should point out, by the way, that when asked about this, he said to reporters at Blake that I'm still working vigorously for O.J. Simpson, and that you should not draw necessarily the inference that I'm either at odds with the defense lawyers or I've located evidence that is adverse to O.J. Simpson. But I think, Kristen, you're right in assessing this. He didn't find anything wrong so far with the procedures, and so why disclose that in a report or notes to the other side? We're going to break away for just a moment, and we'll be right back with more of our coverage. Well, with a flair for the drama and the spectacular yesterday, Chris Darden, outside the presence of the jurors, revealed to the court, we have a witness who can tell us something about the missing knapsack bag and perhaps the blood-stained clothes that could have been, according to the prosecution theory, inside of it. What happened to all of that? Let's go to Dan Abrams. And Dan, is this individual that you identified earlier, this new witness, the only witness on that subject?
That they have another witness who will testify about the bag and possibly the bloody clothes, meaning the reference that Chris Darden made to in court will be backed up by more than just the witness we read about in the sidebar. Now, you remember, the sidebar remark was that there was a witness, O.J. Simpson, zipping and unzipping his duffel bag near the trash can at the airport. That does seem to be somewhat minor, and certainly wouldn't entirely support what Chris Darden was saying. But prosecutors have confirmed that they do have another witness who they intend to call to back up what Chris Darden said in court.
Well, and, you know, it's, I suppose, understandable that O.J. Simpson would be seen doing a great many things in public because he's a very noticeable man. He's a famous face to a great many people. In fact, didn't he, Dan, sign an autograph when he emerged from the limousine?
Well, that's right, and the defense is trying to argue here this is not the type of thing that someone who had just committed a murder an hour ago would be doing. Wouldn't be stopping to sign autographs, basically wouldn't be acting normal, wouldn't be relaxed, wouldn't be able to essentially go on with a normal life. He would be sweating, be completely nervous, and wouldn't be able to cope with the everyday activities that occur in someone's life. And so the defense has been trying to use that signing of the autograph to its advantage. But you're right, almost everything that O.J. Simpson does is going to be noticed. And it seems that someone else has come forward to describe even the most minor of details. And remember, this is something that someone is coming forward about now that happened back in June of 1994.
We were talking about the various ideas and theories that the West Tech security witness might add to the prosecution's case. You've been covering the prosecution's case. Let's get you to weigh in on this.
Well, clearly the prosecution is trying to establish if the alarm was on, that is the reason that O.J. Simpson would have come back to the front of the house as opposed to going in one of these side doors that were blocked and had alarm systems set up. Well, the defense would seem to be arguing, well, if there's a 40-second delay mechanism in the back door, well, then why couldn't O.J. Simpson have gone in the back door and disarmed the alarm and had 40 seconds to go in that way? Well, prosecutors may argue that in that case, the O.J. Simpson would have had to walk around the property, around the back, and then go back in front of Cato Kalin's front door. And he might have been concerned about being seen by Cato Kalin, particularly after having made this noise, this thump, on the back of Cato Kalin's house. And prosecutors may argue that he didn't want to take that risk of going past Cato Kalin's front door. Now, something else that may come up that the defense may argue with regard to that alarm system, whether or not it was on or not, another issue to consider, is Kato Kaelin has identified the clothing that O.J. Simpson was wearing, the sweat-type outfit that he saw O.J. Simpson wearing on that night. If the defense can produce the clothing that matches Kato Kaelin's description, well, then prosecutors may have to establish that O.J. Simpson either went back into his house to change or had another set of clothing with him, prosecutors would probably argue, but certainly they might have to explain how he changed his clothes. And in that case, he might have had to go back into the house, in which case the alarm system, whether or not it was on or off, would come into play again.
There could be so many different theories of what was done that night that fit with the prosecution's theory, Dan, but let's turn to another one, and it's the Ford Bronco. When Alan Park was on the witness stand, he testified essentially that he did not see a white Ford Bronco parked near the Rockingham gate, first when he showed up, and later after he'd had a smoke and then drove for the second time by the Rockingham gate, then backed up and turned again onto Ashford. 2 times. Now, if this is believed by the jurors, does the defense have some response or explanation to that?
Well, we don't necessarily know what it'll be, but one of the defense theories may be that O.J. Simpson had his Bronco inside the compound at the time when Alan Park was driving past the area, meaning that O.J. Simpson could have parked his car out front and then decided that he wanted his golf clubs, and so he drove his car into the Rockingham gate so he could have his clubs right up at his front door, so he could hit the golf balls that the defense is saying that he had hit. He could then have driven out again so that to allow the limousine to come in. So it's possible the defense will argue that when Alan Park was making one of his U-turns to get back into the property, O.J. Simpson was moving the Bronco out of the outside the Rockingham gate to park outside Rockingham so the limousine could then come into the property. It is somewhat of a complicated theory, but don't be surprised if we hear more about that as a possible defense explanation for why Alan Park didn't see the Bronco outside of the estate on Rockingham when he was driving around that area.
Well, Dan, you and I have both been out there. It's a big property, but you would think that the limo driver would notice in the dark of the night another car with its lights on moving around that property at the same time that he's moving around it.
Except if that was the time when he was back making a U-turn at some point, or if this was one of the times when he was going around the block, if it was just happenstance that it was one of the times Alan Park was not just sitting there waiting, and in fact was in the process of moving in another area. Another problem for the defense with that theory is Rosa Lopez. Remember that Rosa Lopez says she saw the Bronco parked out there at 10:30, but again, Rosa Lopez hasn't testified in front of the jury. And if the defense decides that this is going to be the defense theory, then they might not call Rosa Lopez to try and back up the account that the Bronco was parked out on Rockingham for the entire evening.
Okay, Dan, thanks very much. We appreciate your floating these possible theories by us, some more plausible than others, but of course the defense has many options at its disposal. Well, at our disposal is the ability now during this extended recess to bring you up to speed in case you've missed a good deal of the testimony in the murder trial of O.J. Simpson. When we come back, we'll begin showing you some of the testimony from the very beginning in summary form. Stay with us.
She wore blue velvet.
It was the 1960s.
The evidence. You have to understand that the defense will be attacking at every level that they possibly can at this phase. The evidence that was collected at the crime scene is of paramount importance to the prosecution in its circumstantial evidence against O.J. Simpson. So the defense is going to be challenging that, and because of her experience level, they will be challenging that as well.
Well, in your experience as a prosecutor, you've had to deal with a great many criminal incidents. Is it that complicated? We listened to the preliminary hearing, and we listened to some of the pretrial hearings in which Dennis Fung was on the witness stand, Andrea Mazzola. All of their work was really explained, and it seemed as simple as taking a Q-tip cotton swab, dabbing it with a little water, sterile water, and then simply lifting, sort of scrubbing off the surface of the sidewalk or the ground or the foyer, depending upon where the blood is, and it simply lifts up with water. Is it all that complicated? No, and it's a very good point that you make. It really is not that complicated. In effect, it is as simple as you make it sound. The evidence is there and it needs to be collected. It's not a complicated procedure, but the question will be whether or not there's any contamination, whether or not all of the evidence was collected. Given level of expertise, was all of the evidence seen that could have been collected? I think having an experienced criminalist, however, supervising the other criminalist is of importance to the prosecution, and that will be brought up by them as well. Well, you know, that's a funny word, contamination. I think we all understand its general meaning, but with respect to collecting blood evidence, what is contamination?
It's very rare that you're going to find any problem in terms of contamination, but that word, as you say, will raise issues for the jury, and that's the defense hope, you have to understand. What we're seeing a lot of by the defense is challenging through cross-examination, but the answers that are coming out aren't giving any meaning to the questions themselves, but that doesn't stop the questions from being asked, and all they need to do is to plant some seed of doubt. But the truth is that all of the evidence, when it is collected, it's not contaminated, it's there then to be analyzed. And you'll hear the defense, I'm sure, challenging then how it's analyzed as well at each stage.
You can just hear the defense lawyers saying, well, Ms. Mazzola, Mr. Fung, did you wear a protective cap so that hair and dandruff and so forth didn't fall onto the blood evidence? Right. Did you sneeze around it? Did you wear a mask so that simply breathing and germs and bacteria and sort of thing didn't float onto this valuable evidence? What did you do to make sure that each swab or swatch was isolated in a baggie and not all put together and commingled? I mean, you can just hear these arguments. We're going to continue this in just a moment with you because you do have such vast experience on the subject. Let's go to Kristen Myers, though, right now. And Kristen, I understand you have word on a new witness?
Yes, that's true, and it's going to come before LAPD criminalist Dennis Fung. The prosecution has just decided they're going to call a man named Charles Cale, who is a Brentwood resident. And Mr. Cale is going to say, according to Suzanne Childs of the prosecutor's press department, that he did not see a Bronco parked north above Rockingham between 9:30 and 10 p.m. on the evening of June 12, 1994. Now, of course, this is not the time that the prosecutors say the murder occurred at 10:15, but it is important because if you remember Cato Kalin's testimony, at 9:30 they were on their way back from McDonald's and they pulled in, and the last time he saw O.J. Simpson was by the Bronco. Well, this would suggest that the Bronco didn't stay at Rockingham, and in fact it went away over to Bundy, which is what the prosecutors say happened. So no word on why this witness is suddenly popping up out of order, why he wasn't called earlier to substantiate the report of Vallon Park, but in fact the prosecutors say that that's the very first thing they're going to do when we get into the courtroom.
I've got down here on my timeline that at 9:35, Cato Kalin says he and O.J. Simpson returned from McDonald's. Is that about right?
Yes, 9:35 to 9:40 in his testimony he ended up saying. But then at that point, O.J. Simpson either stayed at Rockingham and did a variety of things, or, according to the prosecution, he got back in that Bronco and drove over to the Bundy crime scene. And so, while it's not the exact time of the murders that this witness will say he didn't see the Bronco, it still is significant if he is believed and thought to be credible that he didn't see a Bronco in that period of time after they returned from McDonald's.
One would assume the Bronco would be there between 9 and 9:35, 9:40, because O.J. Simpson is just coming back in the Bentley, so he couldn't be driving two cars at the same time, although this new witness may be off by several minutes in his estimation. I suppose the real question is, where's this witness been?
I know, and I think that's an excellent question. It may just be the prosecution has chosen not to disclose this name to the press for their own reasons, and maybe, remember, one witness had been in Guam for a period of time and was called out of order. So there may be some innocuous explanation as to why this gentleman wasn't called in at a more logical time and that he's being called up now. But I think that the prosecution, as you say, will argue 9:35, 9:40. The point is, he didn't see the Bronco there when it should have been there. They were back from McDonald's, and it should have been parked there, and O.J. Simpson should have been in the home.
Well, you know, Marcia Clark was so meticulous in laying out the timetable and substantiating it with witnesses during her opening statement. One would suspect that this must be a newly discovered witness, though it can't be too new, because if he's going to take the witness stand today, surely the defense has had an opportunity to meet and talk with him, should he be so willing.
And one other thing, Greg, that we should point out, this information was from Suzanne Childs, who's in charge of the press relations for the prosecutor's office. It could be that she is relating generally, she was quoting Marcia Clark, what Clark said the testimony would be, perhaps herself not realizing the significance, the difference between 9:30 and 9:35. And when this man takes the stand, he may have some reason to actually pinpoint the time, and it may well fit into the time structure. We've just been told by this prosecution source that he's going to say there was no Bronco there between 9:30 and 10.
Do you happen to know how it is he knows that time frame, no Ford Bronco?
No, and just that he is a Brentwood resident is the information disclosed. It may be, and Greg, I know you've been out there on a number of occasions to that Rockingham address. It may be that as a resident, having a Bronco parked in that location would be something he'd have reason to notice, because you'll recall when you drive up Rockingham Avenue, it's a small street. It is two ways, but for two cars to pass, you'd be very careful not to hit one another. And it is the kind of street where if a car was parked on the side of the road, you would have to even swerve into what would be the other side's lane to avoid it. So it may be that this witness would say, as a resident of Brentwood, I always notice when people do something that's very annoying to we, the residents of Brentwood, which is park on the side of this small or thin road. It could be something like that. But again, this is all speculation. We know his name, we know where he lives, and we know the essence of his testimony.
No, you're right. Those roads are very narrow, and those residents there happen to be very observant and protective of their neighborhood. So I suppose it's understandable. He may have been walking his dog, perhaps. Maybe he lives across the street. There are several homes there that actually have a view of O.J. Simpson's rather expansive estate, as we've been referring to it. It really is that, because it covers two streets and a large curve that constitutes the intersection of Ashford and Rockingham. Well, we're going to break away for just a moment, and we'll be right back with more of our live coverage here in Los Angeles. Welcome back. We're live in Los Angeles. Nothing happening yet inside the courtroom of Judge Lance Ito and the murder trial of O.J. Simpson. As soon as it begins this morning, we'll go live into the courtroom. In the meantime, there has been yet another surprise. It was yesterday that we learned of a surprise witness who can testify about O.J. Simpson's bag, allegedly, at the airport, LAX. Today we learned that instead of Dennis Fung, the criminalist, first taking the witness stand this morning, it will be Charles Cale, who is a Brentwood resident, who will say that he did not see a white Ford Bronco parked just outside O.J. Simpson's home the night of the killings between 9:30 and 10 p.m. Now let's turn to our guest commentator, Michelle Levine. And, you know, it is not all that unusual that during the course of a trial, especially a trial that is long and much watched, that new witnesses will emerge, is it?
No, and that's absolutely correct. And while you use the term surprise witness, obviously it's not a surprise witness to the defense. Otherwise, we'd be seeing yet another in-chambers conference about why they didn't know about this witness.
Sure.
So it's obviously a witness that is known to both the defense and the prosecution. And
at least for a few days.
At least for a few days. And obviously, the defense is not challenging the ability of the prosecution to put this witness on. But it is not unusual at all that witnesses come out of order and that you have to call people out of order because people are now in their regular routine of their daily lives, and they get on with what they need to do, and sometimes the courtroom needs to accommodate that as much as the witnesses need to accommodate the courtroom schedule.
Let me ask you about a point of law for just a moment. If, for example, Mr. Kale went to prosecutors and said, this is what I observed, but he or his lawyer says, you know what, I'm not going to talk to those defense attorneys. Do the defense attorneys have a right before Mr. Kale takes the witness stand to somehow examine him?
The answer is sort of yes and no. A witness has the absolute right to decide whether or not he or she is going to talk to whomever, whether that be the prosecution or the defense or either one of their investigators. Unfortunately, if a witness does decide, I do not want to talk to the defense, that's one of the things that the defense can bring out in cross-examination. Well, Mrs. Jones, I approached you in the hallway and wanted to ask you a few questions, and you said you didn't want to speak to me. And that in some way elicits some bias of the witness for or against either side.
Let's go back to Kristen Dudette-Meyer standing by inside the criminal courts building as we're about to get underway, we hope. And there's another issue that seems to be re-emerging. The first wife of O.J. Simpson.
That is true. Marguerite Simpson Thomas has been subpoenaed by the prosecution. Remember back a couple months ago, an attorney representing Marguerite Simpson Thomas attempted to quash or stop that subpoena. Well, there was ultimately a hearing after being postponed many times, and the judge ruled it can't be quashed. The prosecution arguably has a legitimate right to inquire of Ms. Simpson Thomas. She spoke to O.J. Simpson on the 17th of June, on the morning before the infamous low-speed pursuit. And that conversation is something prosecutors say they want to ask her about. Also, there were reports from a Los Angeles Police Department officer that over 20 years ago, he responded to a domestic violence call at the home of Marguerite Simpson Thomas and O.J. Simpson. Prosecutors are no doubt interested in that as well, although Marguerite Simpson Thomas has denied that there was any domestic violence in her marriage in television interviews since that report came out. So the prosecution won the right to subpoena her, but as you know, just because you're subpoenaed doesn't mean that you have to be friendly to the prosecutors and allow them to interview you. So that is what Marguerite Simpson Thomas has stated her position is. She's under subpoena, she will show up in court when she is called, and she will sit down on the witness stand and answer questions. But she won't talk to prosecutors before. As a result, the prosecutors have had to keep setting dates where Marguerite Simpson Thomas or her attorney must show up. And these are dates in advance. The prosecutors are hoping that they will have gotten to the portion of their case where they're going back to the issue of perhaps domestic violence, what O.J. Simpson was doing in the week after the murder. Well, we're nowhere near that portion of the case, as you know. And so today, March 31st, was a scheduled day for Marguerite Simpson Thomas to be available. So far, we've only seen one of the attorneys representing her, Maya Hamburger. She is an associate with Carl Jones, who is also an attorney for Marguerite Simpson Thomas. And in one other connection in this case, you may remember that Rosa Lopez was represented also by Ms. Hamburger and Mr. Jones.
They're the only two lawyers in Los Angeles, Kristen. Let's turn to Michelle Levine for just a moment. Isn't this dangerous if you're a prosecutor, and you certainly have experience as that. You're a deputy district attorney in Riverside County for 7 years now. And to put a witness on who you haven't talked to, who has long-standing allegiances to the defendant, and who has made it known pretty much she doesn't much like the way the prosecutor's office has been treating her. Isn't that a danger to put her on the stand?
I don't know danger is the right word. It certainly has its risks, and you can bet that Marcia Clark would be nervous to call her to the stand. But you've also seen Marcia Clark take on a hostile witness when Cato Kalin was not answering questions or certainly was contradicting himself and seemed to be trying to favor the defense over the prosecution. What happens is, as I told you before, if a witness refuses to talk to one side, that is something that can be brought up to the jury. So Marcia Clark could, right out of the gate, ask the witness the question. Each and every time we have tried to talk to you about facts involving your knowledge of Mr. Simpson, you have refused. And it colors her testimony to the extent that it makes her appear as if she would be trying to help O.J. Simpson. What it does, though, as well, is if Marcia Clark was successful in getting testimony from a hostile witness, which is favorable or supports the prosecution's case, it gives it that much more credence and credibility that it is honest because it was so hard to elicit in the first place.
Sure. Now, I suppose the real issue with Marguerite Simpson Thomas is, what does she have to say that helps the prosecution? She's on record as saying that O.J. Simpson never abused me, and if he'd ever tried, I would have knocked him upside the head, I think she said, with a frying pan, if I recall that correctly. And her other statement was that on the day of the low-speed chase, she said her ex-husband, in the telephone conversation with both her and her older son, Jason, that he was suicidal, and that he was asking, please take care of my two youngest children in some regard and make sure that they understand their black heritage and so forth. I mean, these are all quite helpful to the defense. What in the world could prosecutors get out of her?
It's a double-edged sword. I would tend to believe that if they keep having her ordered back to appear in the courtroom, that obviously, one, they consider her a hostile witness, but two, that they must have something in writing or some information from a police officer or some source that they trust that she does have information that could help them. But obviously, the detriment in calling her as their witness to the stand is that they have to then question her directly. It's a direct examination, and they cannot ask leading questions. The defense, in turn, can ask leading questions of her and can, as you say, set out all of the information that would be very helpful to O.J. Simpson.
Yeah, well, it would be interesting to see if it happens. We're going to break away for just a moment. Again, nothing happening inside the courtroom right now, a delay which is now standard operating procedure. We'll be right back with more of our live coverage. Although there will be apparently, and I guess we're calling it a surprise witness, surprise to us, and maybe a surprise several days ago to the defense, a resident of Brentwood will be taking the witness stand once they commence this morning, and they haven't yet begun. He will testify that he did not see a white Ford Bronco between 9:30 and 10 p.m. the evening of the killings. And after he leaves the stand, prosecutors then begin this new phase, and it moves into the scientific aspect of the case. The blood evidence, the hair and the fiber, all of it collected and tested. And prosecutors believe they can connect O.J. Simpson to both the murder scene and, in fact, the bodies of Ron Goldman and Nicole Brown Simpson. To do that, of course, they have to begin in the beginning with Dennis Fung, who is one of the two criminalists who helped lift from both the murder scene and O.J. Simpson's estate some of the valuable trace evidence. Let's revisit for just a moment. Dennis Fung on the witness stand July 7th during the preliminary hearing in municipal court before Judge Kathleen Kennedy Powell. And this will give us a pretty good preview of how it may go today. And he is describing what he did on the morning of June 13th, 1994, just hours after the killings, what he did at O.J. Simpson's Rockingham estate.
Now, were you called out to process a crime scene at approximately 5:30 a.m. on June the 13th, 1994?
Yes, I did. Yes, I was.
And to what location were you directed?
The location was 360 North Rockingham.
You arrived there when?
I arrived there at 7:10.
And when you arrived there, did you make contact with a detective?
Yes, I did.
Who was that?
I was met there by Detective Van Adder.
And what occurred when you contacted him at that location?
Detective Van Adder briefed me on the crime scene. He showed me bloodstains on a Bronco on the driver door exterior handle, and also blood drops along the driveway and a glove on the south side of the house.
I'm directing your attention, sir, to People's 8. Photograph A. First of all, can you tell us who's the gentleman shown in photograph A?
That appears to be me.
That you?
Me, yes.
Okay. Do you remember the item that you're pointing to in photograph A?
Yes, I do.
What is that?
That is what I believe to be a blood stain.
And what is being shown in photograph B?
Photograph B is a close-up of the suspected blood stain with a scale in it.
And for what purpose do you have that ruler in there?
The ruler's there to indicate the size so that we have something to judge how large that stain was.
What does that number 1 in there mean?
The number 1 is a photo ID number used to document the evidence.
Do the photo ID numbers, excuse me, correspond to item numbers in property reports that are prepared by yourself?
Many times they do, but but there are times when they do not.
Well, when I say correspond, what I mean is that does every item number have a corresponding photo number?
Yes. Or it should.
Okay. And sometimes the ID, the item number, and the photo number are the same?
Yes.
But not always.
That's correct.
In this particular case, with respect to the photo number you've indicated in B, which is 1, for the stain on the door handle,
Yes.
do you know what the corresponding item number is?
The corresponding item number is item number 1.
What, if anything, did you do with respect to that spot that you appear to be pointing to in photographs A and B?
The spot was tested with the presumptive test and came back positive. Then it was measured and ultimately documented and collected.
Now that was during the preliminary hearing. We may hear Dennis Fung say very much the same thing, only you can expect a lot more. Here's what Marcia Clark said was located at the O.J. Simpson estate and that Fung helped collect. 2 drops on Simpson's driveway that prosecutors can identify, they say, as O.J. Simpson's blood through DNA testing. On the floor in O.J. Simpson's home, Simpson's blood. And socks found at the foot of Simpson's bed. 1 spot was O.J. Simpson, said Marcia Clark. 1 spot was Nicole Brown Simpson. Let's go to Kristen Jeanette Myers. And Kristen, there's been a delay this morning, not at all unusual. What's the holdup today?
Well, and it is not related to Marguerite Simpson Thomas, because we've just received information that there's not going to be anything in court about that. The prosecutors aren't ready to question Marguerite Simpson Thomas if they ever decide to at all. And so a new date will be set through her attorney, and she will be required to come back at that later date. What is going on in the courtroom concerns a videotape. The defense complained yesterday that they did not receive a copy of a videotape that was apparently made on June 13th during the execution of the search warrant at the Rockingham estate. Now, the reason the defense knows that this videotape was made is because they saw it on TV. There were many cameras there taking pictures that day, and in some of the footage you can see people who appear to be from the LAPD. One of them has a badge hanging sort of off of his clothing with a small camcorder taking pictures. So Barry Scheck for the defense yesterday demanded to know where's that tape and why haven't we got it in discovery. He was informed by Sherry Lewis that the tape was made by the SID division of the LAPD, that's the Scientific Investigation Division, but that it was done as a matter of course when such search warrants are executed because of liability issues. The LAPD has faced in the past. They want to document the condition of the premises, and they want to document the fact that when they leave, it is in similar condition. That's why the tape was made. And so, as Sherry Lewis was saying, we didn't turn it over because it has nothing to do with this case. It isn't anything we ever used. The defense was upset about it. The judge said, let's try and see if we can handle this without having motions and hearings. So he ordered the detectives who took the videotape, specifically Detective Looper, to show up at 8:30 this morning, meet with the defense, and discuss what it is that was the purpose of this tape and why it wasn't turned over. If they can work it out amongst themselves, then we may not hear about it anymore. But in this case, that rarely happens. And so maybe when we go into court, we will hear the defense position on the fact that they never received this videotape.
Well, was it ever listed by prosecutors as part of their presentation of evidence?
No, not at all. It was something that prosecutors seemed to indicate that they didn't have custody of, that they didn't have interest in, and that it was something, as I say, done as a matter of course by the LAPD to protect themselves from liability. There have been a number of cases over the past, I'd say, 5 years, and one prominently I'm thinking of that involved Michael Stone, who was a defense attorney in the Rodney King case and who Court TV viewers might know, but where the LAPD was put on trial and accused of doing great damage to the homes of people where a search warrant was being executed. An infamous case here in Los Angeles where the police were convicted, essentially, in a civil case of doing just that and of behaving very inappropriately while executing a search warrant in someone's home. And so I think as a result of this, the LAPD needs to protect itself and show that it is properly executing search warrants.
Well, we recall this videotape being brought up before. Hadn't the defense earlier requested a copy of the videotape?
I don't recall that, Greg. If they've requested a copy, the prosecution's position is it's not appropriate discovery because it's not something that they did as a part of their investigation of the case. However, yesterday, the accusation by Barry Scheck was that it was somehow being hidden and that it was something they were entitled to and had to discover through the media. And so they are, as I say, trying to work it out with each other. There is another videotape that you might be thinking of on the June 28th search warrant. Prosecutor's office members did make a camcorder recording of that June 28th search. That tape has been turned over. That tape was listed as part of the prosecution's evidence, and that tape is not an issue.
Well, if it's standard operating procedure, and these are experienced defense lawyers here in Los Angeles, they probably know that this SID tape is routinely made during the execution of search warrants. So let me turn to Michelle Levine, our guest commentator. Is this the kind of thing, although not made for the purpose for which the defense now wants to use it, but I would argue it's pretty relevant if they're claiming that the collection of the evidence was in some way mishandled and fouled up and contaminated. This might be pretty good evidence of it.
Well, there are two things, two comments that I have to that. One is that regardless of the purpose for which the tape was originally made, obviously a picture's worth 1,000 words. And so the camera recording itself is, as you say, very relevant, at least to be able to show the appearance of the scene at the time the evidence was collected. Yeah. But it is not, the second thing that I wanted to say was it's not unusual at all, though, for law enforcement to make these kinds of videotapes or to do things that are either, one, not known to the district attorney's office, or two, that the district attorney's office is not retaining or possibly has not seen at all themselves. So in terms of a discovery issue, I don't think this is any attempt by the prosecution to have hid the ball in any way, but certainly once it becomes available, I think this hopefully will be something that can be handled without the motions and written legal arguments.
So the bottom line is probably if the defense wants it, they get it.
Probably.
Would prosecutors then probably welcome that and say, look, this tape is perfect evidence of how our pros at the crime scene, our criminalists who are highly experienced, although one of them was a trainee, did it right?
I think so, and I wanted to revisit another issue. One, it will show the trainee, but two, just because somebody is doing something for the first time, at least at a crime scene, does not necessarily mean that there's any problem with what was done, nor does it mean that she is not trained and very skilled in collecting the evidence that she did in fact collect. But yes, it could be very welcomed evidence by the prosecution, and my guess is it would be.
Would you, if you're the prosecutor, say, look, because she's new, perhaps she's a lot more meticulous than somebody who's been doing it routinely over the years and might, because of that, grow a little sloppy?
I think that's a very good point. I think that's a very good point. And that does, I don't necessarily believe that experienced criminalists get sloppy, but I do believe that somebody who's brought out to the crime scene, understands that the job is very, very serious, is going to be very meticulous in the manner in which she collected the evidence.
Dennis Funk testified in the preliminary hearing that with a particular drop, he might take several swatches. That is to say, as we explained before, taking a swab, cotton cloth, which is sterilized, dipping it in sterilized water, lifting the blood. Now, he might do that several times with a spot. He then testified, if I recall correctly, that he would then, with respect to that one blood spot, put the different swatches in the same envelope. Now, and we heard Robert Shapiro, I think, or Gerald Ullman say, well, that's confusing, two different swatches and contaminating each one. I mean, the trace of one swatch will go to the trace of the other. It commingles it, and that contaminates it. Is that true?
Well, I think I'm going to leave it up to the criminalist to discuss a lot of that, but in a word, no, I disagree. Obviously, when a criminalist is taking one particular sample and sees a very small sample and is trying, I think what he was trying to do was to get a number of different swatches so that then those individually could be tested with varying different tests instead of having it on one source, and then it would be very difficult to be able to split or separate and have either the defense test it or subject it to various different tests.
It seems to make sort of logical sense that if you're just simply drawing it from the same blood drop, it's okay to put the swatches in the same envelope.
Sure.
Yeah. Okay, we're going to break away for just a moment. A delay again this morning. We do expect Charles Cale, a Brentwood resident, to be taking the witness stand to testify about what he saw or didn't see the night of the killings.
Hello, I'm Dan Broden with the Court TV Docket Report. Join us tonight at 10 p.m. Eastern and Pacific Time for Washington Watch. This week, anchor Fred Graham and his guests will look at the Senate's attempt to curb online obscenity. Will preventative measures violate the First Amendment? Also, an interview with the man conducting the Clinton administration's review of affirmative action policies, and a discussion about a court challenge to the Brady gun law. That's on Washington Watch tonight at 10 p.m. Eastern and Pacific Time. And join us Monday at 9 a.m. Eastern Time for a New York trial in which a homeless man is charged with the murder and attempted robbery of a former Rockette dancer. Alexis Welsh was walking her dogs at 5:30 in the morning in June of 1991 when she was allegedly stabbed by Kevin McKeever. McKeever, who has a long history of mental illness, denies any involvement in the killing. That's New York versus McKeever Monday at 9 a.m. Eastern Time. That's the Court TV Docket Report. I'm Dan Broden.
During the opening statement a few months ago in this case, Marcia Clark told the jurors several important things about the physical evidence discovered at the murder scene. First of all, she prefaced her remarks by saying O.J. Simpson cannot account for his whereabouts approximately from 9:35 that evening to about 10:45 to 10:50. And she says, the physical evidence will show he was not at his home, as stated in his alibi, but rather at the murder scene committing two heinous killings. And specifically, she referred to the following: a ski cap that was found at Ronald Goldman's feet. And on it, she said, Simpson's hair and hair from trace evidence located in the carpeting of the Ford Bronco which Simpson drove. Second of all, on Ronald Goldman's shirt, O.J. Simpson's hair. And third, there was a glove that was found at the murder scene, and on it, she claims, there is hair matching Nicole Brown's and Ronald Goldman's, fiber from Ronald Goldman's shirt, fiber from the white Ford Bronco that O.J. Simpson drove, and importantly, most importantly, a mixture of O.J. Simpson's blood Nicole Brown Simpson's blood and Ronald Goldman's blood. Now, there were two people who helped collect that trace physical evidence. Andrea Mazzola, a criminalist who was a trainee with the LAPD, and her supervisor, Dennis Fong, who was a very experienced criminalist with the police department. He is expected to take the witness stand sometime this morning once the trial resumes, and it's in a holding pattern right now. And so let's revisit his testimony about what he discovered at the murder scene and what he collected in the way of the glove and the knit cap.
Now, sir, did you recover a glove from the location of 875 South Bundy?
Yes, I did.
Showing you the photograph that has been previously marked as People's 12. Can you tell me if you recognize what's shown there?
Yes. In the photograph marked People's 12, a brown glove is depicted along with a photo ID number 102.
And that photo ID number 102 corresponds to what item number, sir?
Photo ID 102 corresponds to item number 37.
Did you prepare a report concerning any analysis you may have performed on that item?
I did not do an analysis of the glove at the scene.
You did not?
No.
Why not?
It was not necessary for the investigative process at that time.
Directing your attention, sir, to a photograph that has been previously marked People's 11. Can you tell us what's depicted there?
The photograph marked People's 11 depicts a dark blue watch cap, and next to it is a marker with the number 103.
And that corresponds to what item number, sir?
That corresponds to item number 38.
And what test did you perform on that item?
No test was done on the cap at that point in time.
Why not?
Was not necessary for the investigative process at that time.
What do you mean by that?
It is best to not manipulate the evidence and to leave it in as much an undisturbed condition so that it can later be analyzed in a proper setting back at the laboratory. By manipulating the evidence out at the scene, valuable trace evidence could be lost. So what we try to do is just leave it as undisturbed as possible and by packaging it and bringing it back to the lab.
So you try to do as little testing as you can of items in order to preserve them?
Yes.
And only if it's absolutely necessary do you test them at the scene?
Yes.
Well, that was some of the testimony of Dennis Fong, who was the supervising criminalist with the LAPD, collecting evidence, not just at O.J. Simpson's estate, but there, as you saw, at the murder scene. He spoke of trace evidence. We often speak of it a bit too freely. It is kind of a technical term. What does it mean?
Basically, what we're talking about is evidence that sometimes can be seen with the naked eye, sometimes cannot be, but it's very small amounts of evidence that's at a scene. And so you want to meticulously go through a scene and be able to collect it Sometimes at scenes, you'll actually see criminalists cutting an entire section of carpeting just because of one small piece of a mark in the carpeting that they want to retain. So all of those things are going to be collected. And as you mentioned earlier, the swabs that were taken, all of those are bits and pieces of this trace evidence that then gets analyzed, and then those opinions based on the analysis that ultimately leads back to the evidence that was at the scene, that becomes important for the jury to know.
All right, now here's what Marcia Clark said during the opening statement. Look, some of O.J. Simpson's hair we will be able to demonstrate was found on Ronald Goldman's shirt. But the detectives did something that they probably now regret, or if they don't, they should. They pulled a blanket from Nicole Brown's condominium and they draped it with good intentions, of course, on top of one of the bodies. That hair, because O.J. Simpson was frequently at Nicole Brown's condominium, that they now identify as O.J. Simpson's may have come from that blanket. Isn't it possible? Haven't they now destroyed the value of the hair evidence on the two bodies?
I don't know that they've destroyed the value. I think what has happened, as you've indicated, is unfortunate. What it's done is it's compromised in part what has been found, and it gives, once again, an argument to the defense to be able to say it is possible, and they raise the specter once again that the evidence in some way has not been handled correctly, and that is in essence the theme for the defense case.
Why would you do that? Put the blanket on top of one of, I mean, aren't you supposed to use sort of, sterile sheets or plastic bags?
You know, I think we have this image, and maybe people have this image of a crime scene being able to be so roped off, and almost the invisible dome of silence coming down over it and protecting everything inside, and it just simply isn't that way. Murder is a very messy business, and it is very difficult to preserve different things. Obviously, it's done with as much caution and concern to retain the evidence as possible, but sometimes it is more difficult than one would think.
Yeah, we're humans. We make mistakes, all of us. Police officers, attorneys, television newscasters. Let's go to Kristen Jeanette Myers. Kristen, you have some new information on the holdup?
Yes, in fact, what is going to happen now is at 10 o'clock in just a few moments, we're going to go into court and the jury's going to hear testimony. Remember, this is an abbreviated day, and so the judge wants to get the show on the road in front of the jury. And so they're going to come in at 10, and testimony will be heard from this new witness, Mr. Kale, the Brentwood resident, who says he didn't see a Bronco between 9:30 and 10 p.m. on the night of June 12th. However, what was happening was this attempt to unofficially, without filing motions and getting into having hearings, work out the problem of the fact that the defense did not get this videotape that was made on June 13th while the search warrant was being executed at O.J. Simpson's Rockingham estate. Well, I just had an opportunity to talk to Detective Looper down in the hallway, because they have been told that they have to stand by. The issue has not been resolved, and after the jury hears testimony and leaves for the day, Detective Looper and his people, he was flanked by at least 4 other LAPD members who look to be high-ranking, and they will be back to try and work this out. What he did tell me is that the defense got a copy of this videotape on March 24th. He said it was not made in connection with the case, that it was made for administrative purposes, and he said it was a a CYA is how he then put it. And he said that when you're going into a home of someone such as O.J. Simpson, with a lot of valuables and a lot of potential for destruction of valuables, or even accusations of theft of valuables, the department wants to protect itself and to have a tape showing exactly what was done and how it was done in the event that there is ever a complaint. He did say this is not normal procedure per se when a search warrant is executed, because most of the places they go to search don't have this kind of a problem. But he did say it is normal procedure when it is an estate like O.J. Simpson's or some other situation where there could be a controversy that might arise later.
Okay, Kristen, thanks very much. Amid the sound of jackhammers, we'll break away for a moment. We'll be right back with more of our live coverage here in L.A. are told that the court session should begin shortly, perhaps in the next 5 or 10 minutes. There has been a delay today, and the first witness will be a neighbor of O.J. Simpson's. He'll talk about whether or not there was a white Ford Bronco parked out front of Simpson's estate between 9:30 and 10 p.m. A bit of a surprise witness. But then we'll move to the third phase of this case, and that is the scientific evidence, the blood evidence, the hair, the fiber, all of which was collected both at O.J. Simpson's estate and at the murder scene. This will be familiar territory, not just for the attorneys, but for the witness, Dennis Fung, a supervising criminalist who helped lift that trace evidence. And so let's revisit his cross-examination. Dean Gerald Ullman did the questioning. This was July 7th, 1994.
Now, let's refer first to the investigation you did at the Rockingham address. I believe the location of item number 9, the glove that you recovered at Rockingham.
Yes.
That was particularly called to your attention by Detective Van Adder?
Yes.
And what did he ask you to particularly look for in your process of recovering that glove?
At one point, he asked me to see if there was any blood on the glove.
Anything else?
He asked me to measure it and preserve the evidence also.
Anything else?
That's all I can remember.
All right. Now, to ascertain whether there was blood on the glove, you did a presumptive test.
Yes.
You applied a cotton swatch to the glove?
No, a cotton swab.
Cotton swab?
Like a Q-tip type thing.
All right. What portion of the glove did you apply that swab to?
I believe whatever area was facing upwards, I looked for a darker area than appeared on the rest of the glove, and applied the wet swab to that portion and performed the rest of the test.
Do you recall where that portion was?
No, I don't.
Was the glove lying palm up or back up?
I'd have to refer to the photographs.
All right, let's do that. Putting Exhibit 4 up.
I'm sorry, is that 4? My note was that 4 had been withdrawn.
I believe that's 9.
This is number 9?
Number 9.
Okay.
Excuse me. I'm sorry, I have 2 numbers on it. The grand jury exhibit is 4, this is exhibit 9.
Okay.
Have you located where you applied the swab to the glove?
I don't recall where exactly I applied the swab to the glove.
Right. Does the photo in Exhibit 9D depict the position of the glove as you found it?
From the best of my recollection, yes.
Now, you mentioned that one reason you don't routinely do presumptive tests on all of the evidence that you encounter is because the manipulation of the evidence may lose valuable trace evidence, I believe you said.
Yes.
Right. But you did manipulate the glove in order to do a presumptive test, is that correct?
Yes, I did.
Now, were you, or did you attempt to locate any stains or footprints in the location leading up to that glove?
I looked for them, however, I did not find any.
Did you examine carefully for any disturbance in the pattern of debris leading up to the glove?
I did not notice any discernible pattern of that I could differentiate from randomness.
Well, would that assist you in ascertaining whether someone had dropped the glove there or whether they had thrown the glove there from some other location?
I don't really understand the question.
Well, we're interrupting our revisiting of the cross-examination of Dennis Funk, who may later today take the witness stand for an update. Let's go to Kristen Jeanette Myers. And Kristen, we've been talking about the holdup this morning. What more do you have?
In the ongoing saga of the videotape made by police officers on June 13th during the police search of O.J. Simpson's Rockingham estate, it appears the parties have not been able to work this out without the assistance of Judge Ito. And so the schedule now is this. At 10 o'clock, and it already is 10 o'clock, so within minutes they're promising, court will convene and the jurors will hear testimony from Charles Cale. We're live right now. Let's go in and watch.
Counsel, Mr. Shapiro, Mr. Cochran, Mr. Neufeld, Mr. Douglas, people represented by Ms. Clark and Mr. Darden. The jury is not present. Counsel, is there anything we need to take up before we ask the jury to join us? Mr. Cochran.
Your Honor, there's an even quicker manner. There's another attorney here who's representing Marguerite Simpson Thomas. There's a bench warrant issue and held until today, and it's my understanding, Mr. Darden, and that attorney whose name escapes me have agreed on May 5th.
May 5?
May 5.
Cinco de Mayo?
Yeah.
All right, bench warrant. Is that date agreeable to your calendar, counsel?
Yes, that would be fine. Thank you,
All right,
Your
bench
Honor.
warrant will continue to be held, issued and held to that date.
Thank you.
Thank you, counsel.
Yes, the court, Your Honor.
Mr. Cochran, good morning.
Good morning, Your Honor. Your Honor, yesterday there was a witness called by West Tech, and in the course of the proceedings, much was made of the security system at Mr. O.J. Simpson's home. And as the court knows, in this case, there are a number of people watching in, and we received a number of calls from people who were concerned, some of whom were even in state prison, about knowing about Mr. Simpson's security system. And I wanted to indicate for the record that due to this testimony regarding West Tech, Mr. Simpson's security system has now been totally changed, and there are armed guards on the property. I mention this because we always have concern for security. The court knows there are still occupants of that home. And I think it's important that everyone know that at his own expense, Mr. Simpson has done this, and he has a strong desire to not have his property invaded or intruded, and that his rights of privacy are protected, and he has paid out of his own pocket to have that entire system revamped and reconfigured as of last night. So I guess it's kind of a little burglars beware, if the court pleases.
All right. Thank you, counsel. All right, Mr. Darden, good morning. Are you ready to proceed with your next witness?
Yes, Your Honor.
All right, anything else we need to take up before we invite the jurors to join us? All right, Deputy McNair, let's have the jurors, please.
So while the jury comes in, we've got about 20 seconds. Michelle Levine, every morning the judge sort of, you might as well say, would anybody like to make a speech? Is that normal?
No. It's obviously an opportunity for the attorneys to be able to speak outside the presence of the jury. But in this kind of a case, when we've had delay after delay, it's surprising to me that the judge is allowing yet more use of the court time and taking away from the jury hearing evidence.
Yeah. In this particular case, sort of, you know, for the benefit of O.J. Simpson, in the eyes of the public, you know, to say this poor man has now had to go change his security system. I mean, it has nothing to do with the case.
No, nothing at all. And obviously, in a sense, Mr. Cochran said exactly what it was. Burglars beware, and he just wants everyone to know that the system has been changed and the house is secure.
Yeah. Well, sometimes the speech-making in the morning has to do with what was seen on the morning news programming or the night before on the network magazine shows and so forth. It is generally a free-for-all every morning to engage in some speech-making. They try to tie it in to some of the evidence, and sometimes it's not even close, but the jurors are brought back in. Let's go live.
Ladies and gentlemen, record to reflect that we've been rejoined by all the members of our jury panel. Mr. Darden, you may call your next witness.
Thank you, Your Honor. Good morning, ladies and gentlemen.
It's Friday.
Yes, it is Friday, isn't it? Thank you, Your Honor. The people call Charles Kale.
All right, Mr. Kale, would you come forward, please?
Sir, can you please raise your right hand? You do solemnly swear that the testimony you may give in the trial not being in for this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat. Your witness stand and state so your first and last name for the record.
My name is Charles Kale, C-A-L-E.
Good morning, sir. Mr. Kale, on June 12 and June 13, 1994, did you live in Brentwood?
Yes, sir, I did.
Okay. And during the month of June 1994, were you familiar with the defendant's, or rather the location of the defendant's home at 360 North Rockingham?
Yes, sir.
Had you been to that residence before?
I'd been by it. I'd been on the property on a holiday, something of that sort.
Okay. And are you acquainted with the defendant, O.J. Simpson?
We've seen each other in the neighborhood, and I know him from passing. And
okay. Did you own a dog on June 12?
Yes, sir, I did.
Okay.
Still do.
Okay. And directing your attention to the morning following the murders of Ron Goldman and Nicole Brown, and this will be Monday, June 13, 1994. On that date, at approximately 7 o'clock in the morning, were you on Rockingham?
Yes, sir, I was.
Okay. Were you in a car?
Yes, sir.
Were you alone?
No, I was having somebody drive with me to the airport to take my car back home.
Okay, so you were en route to the airport?
Correct.
Okay. And on that date, Monday, June 13, at 7 a.m. in the morning, did you drive down Rockingham?
Yes, sir.
Okay. And did you pass the defendant's residence at 360 North Rockingham?
Yes, sir.
Now, from which direction were you driving?
I was driving from north to south.
Okay. So you were, it's right there. And as you approached the defendant's residence, did you have to pass through the intersection at Ashford?
Yes, sir.
And did you pass through that intersection?
Yes, sir.
Okay. Now, you've been at that intersection before, at Rockingham and Ashford, is that right?
That's correct.
Okay. And I take it that you passed through the intersection on your way down to Sunset Boulevard?
That is correct. That's.
Yeah. And is there a path or a course that you usually take as you drive down to Sunset?
Yes, sir. There is.
Do you usually pass through the intersection at Rockingham?
Usually I would turn left if I were going to be going east on Sunset to go across to Cliffwood, and turn left at Cliffwood because there's a light. And you can't turn left onto Sunset from Rockingham. If you're going down that way, there's no left turn sign.
Okay. Now, do I understand you to say that you would usually turn left at Ashford?
Yes, sir.
Okay. Did you turn left at Ashford that Monday morning?
No, sir.
And why not?
Because I saw a black and white patrol car, police car, parked in the street, just east of Rockingham on Ashford, between the corner and the gate in the entrance into Mr. Simpson's home on Ashford.
So you couldn't turn left?
Could have turned left and gone around, but it would have been, we had to go out of the way or off into the left lane.
Okay. And so did you continue then south on Rockingham?
Yes, sir, we did.
Did you pass the defendant's gate, the gate to his residence at 360 North Rockingham?
Yes, sir, I did.
And as you did so, did you notice a vehicle at all?
I did. I noticed the white Ford Bronco.
And where was the white Ford Bronco when you first saw it that Monday morning?
It was just to the north of the driveway, the Rockingham driveway, parked at kind of a strange angle with the rear out from the curb a little bit more than normal.
And did you pay particular attention to the Bronco?
Yes, sir. I was surprised to see it, and so I noticed it.
Okay. Why were you surprised to see the Bronco at that time?
Well, very seldom, if ever, had it been parked there. In fact, seldom, if ever, were any cars parked on the Rockingham side of the street as I went along from the past. And I noticed that. I noticed that it was parked at sort of a strange angle. I mean, you could tell it was out. The rear wheels were out a little bit. And also, I had not noticed it the prior evening.
You had not noticed the Bronco parked on Rockingham the prior evening?
That is correct.
Okay. Were you outside the prior evening?
Yes, sir.
Okay. This would be Monday, or rather Sunday night, June 12th.
Sunday evening, June 12th.
And why were you out Sunday evening, June 12th?
Well, I had taken my dog for a walk. I had been packing to get ready to go to the trip early the next morning, and I took the dog out for a short walk and had been walking on Rockingham. And when I was walking, I hadn't seen the Bronco.
Okay. Now, what time was it, if you recall, that you walked your dog Sunday evening?
About 9:30, 9:45 period.
And so during this time period of 9:30 to 9:45, you say you didn't see the Bronco on Rockingham?
Yes, sir. I did not see the Bronco on Rockingham.
Okay. Now, from which direction were you walking with your dog?
I was walking from north to south.
North to south on Rockingham?
That is correct. And then I returned and walked back south to north.
Did you ever pass the defendant's home at 360 North Rockingham, that is Sunday night?
No, sir, I did not.
Okay. How close did you come to the defendant's gate located on Rockingham Sunday night?
I would estimate about 60 yards, probably.
Now, you mentioned a moment ago that seldom, if ever, have you seen the Bronco parked on Rockingham.
That is correct.
Have you seen the Bronco parked at other locations?
Yes, sir, on Ashford on occasion.
Have one moment, Your Honor.
Certainly.
Well, that last statement matches Cato Kalin.
I am missing Mr. Fairtlow at this moment in time.
The last statement matches what Cato Kalin testified to, that the Bronco was normally parked outside the Ashford gate and not outside the Rockingham gate, as it ended up being late that night, early the next morning.
Do you want to just proceed with the normal photographs?
I'm sorry?
Do you want to proceed with the normal photographs and just do it the old-fashioned way?
Yes, Your Honor. Mr. Kale.
Yes, sir.
The time you just indicated, you just told us that you were out at around 9:30 to 9:45 p.m. Sunday evening?
Yes, sir.
Okay. And
I'm sorry, Your Honor.
Should be right there.
Oh.
Certainly. Mr. Darden.
Okay, you indicated that you were out around 9:30 to 9:45 p.m. Sunday night.
Yes, sir.
Okay. And how is it that you arrived at that time? That is the 9:30 to 9:45 p.m. time.
Well, I had come back earlier in the evening with one of my children, and we'd had dinner, and then I had started to pack for my trip the next morning. Put my materials together to go on this trip. I know that I came back and went to bed shortly, about 10 o'clock or very shortly thereafter, because I had to get up early the next morning. And I know that when I got done with the packing and before I went to bed, I went out for a short walk, and that's the best estimation I can have, is about between 9:30 and 9:45.
Sir, how certain are you that the Bronco was not parked near the gate at Rockingham that Sunday evening?
I'm very certain.
Perhaps Mr. Harris assist you with that?
Well, normally this would be flashed up on what's known as the Elmo, which is a large screen so that the jurors can see. The witness has a small monitor, but the operator of the Elmo, as it's known, apparently isn't inside the courtroom, so they're doing it the old-fashioned way, as Judge Lancito said. Just show the photograph without the use of the overhead projector.
Yeah, I have a photograph here, an aerial photograph, and if you mark the information on it.
157.
Well, now it looks like the Elmo operator is
the
back,
Elmo.
so they can use it on the overhead. It's a little bit, moves things along because you don't have to hand it juror by juror, the photograph, so everybody can see it at once. Cuts down the time considerably. And we get to see it as well.
All right, you see your monitor there, Mr. Gale?
Yes, sir.
All right. Mr. Darden.
Looking at that photograph, Mr. Kell, can you indicate for us the point, or rather the closest point that you came to the defendant's gate on Rockingham?
Well, I just have to align myself here. It was in the area of, as you look at Rockingham, about a little farther than halfway up on the top to bottom line here. You see there's something that's sort of red, a vehicle of some sort that's red, and then, which would be on the east side of the street, and then if you come across diagonally, there's a car, looks like a car, a lighter colored car, on the west side of the street.
Mr. Kell, we're going to place an arrow on the screen. If you will, please direct the arrow.
Well, okay, bring the arrow north on Rockingham. Farther. And now go to the right there. So a line from that vehicle across to the left to the vehicle on the west side of Rockingham down here.
So you are on the opposite side of the street?
No, that line in there, the right, going all the way to the corner, right in there, that area.
Right there. Okay, can we come back and just place the arrow?
I would say that would be That's the general area, not all the way to the corner, but
Okay, can we come back and take them?
past the driveway on the right for the house on the north side of the street.
All right, so you're on the west side of the street, is that correct?
I was walking in the, in the street, not just necessarily on the dog sort of goes back and forth, and there. At the time, there wasn't really very much traffic on Rockingham.
Now, when was the first time that you were interviewed by the police, Mr. Kale?
I would say it was in January, I think. I don't know the exact date, but it was in, I believe, in January of this year.
And did you contact the police?
They contacted me.
Now, you do live in the area, is that correct?
That is correct.
Okay. And you would prefer not to have your address published, I take it?
That is correct.
Now, when you walked down Rockingham that Sunday evening, were you able to see Ashford Street?
Well, excuse me. Bits and pieces of Ashford Street, because as you can see from the picture, there are a lot of trees, and if you walk down Rockingham, the trees really break up an unimpeded view of Ashford. You can see parts of Ashford.
Okay. Did you see the defendant's Ford Bronco parked on Ashford Street that Sunday night?
I don't recall seeing it on Ashford, no, sir.
Thank you, that's all.
Mr. Shapiro?
Thank you very much, Your Honor.
And this is now cross-examination by the defense.
With reporter?
Yes.
And so there is a sidebar conference here. Let's compare the testimony of Mr. Kale to what happened on Tuesday of this week. Alan Park, the limousine driver, also spoke about what he saw that evening at a critical time period, about 10:40.
When you looked to your left to look up the Rockingham gate, were you looking very carefully to in that direction, sir?
Yes, I was.
And did you see any white Bronco parked to your left north of the Rockingham gate?
No, I didn't.
And that was the second pass that this witness had taken along that Rockingham Road near the gate of O.J. Simpson, where the car was later discovered the next morning. And so not only is there Cato Kalin, who has testified about how the Bronco is normally parked on Ashford and not on Rockingham, but you also have the limousine driver who didn't notice the Ford Bronco as he passed by twice that evening along the Rockingham gate. Now, Mr. Kale. It's interesting, Michelle Levine, as we're taking a look inside the courtroom, there doesn't seem to be anything going on. They're still in the sidebar conference. It's interesting that this is somebody who wasn't contacted by police till January.
Well, that's true. It may very well be that his appearance or his knowledge of the scene was completely unknown. We've seen in the past that there are people who live in the area that, although they have that as their residence, they often spend time elsewhere. We had a witness who lived in Guam for a short time. So it's possible that the witness was unknown or unavailable, and obviously once he became known, provided what is very helpful information in terms of, again, that time period and whether or not the car was actually there. I would expect that the defense is going to ask some questions about whether or not this particular witness saw the limousine driver, or whether or not the limousine driver could have seen him. That may be protected because of the distance, the 60, I believe he said he was 60 yards or so from the Rockingham residence of O.J. Simpson. So it may be understandable if they did not see one another. But
And the limo driver didn't show up till about 10:22, 10:23, so this would be after the time that this witness had passed by with his dog. They're still in a sidebar conference. We'll break away. We'll be right back with more of our live coverage. Robert Shapiro cross-examination.
Memory if that report is dated January the 25th?
That sounds, as I was going to say, late January, early February.
And they called in response to the fact that you had called someone else and asked to speak to someone regarding this incident. Isn't that correct?
No, that's not entirely correct, no.
Have you seen the report in this case?
I saw it very briefly this morning.
Let me give you an opportunity. Well, let me just ask you. The report is a page and one paragraph?
Yes.
And was that report, when you had a chance to review it, accurate?
I took a very short, brief look at it. I thought it generally seemed accurate.
Do you know a person by the name of Jay Gardner?
I do.
Is that Jeff Gardner?
That is.
And who is that?
He's a friend.
What does he
He's
do?
also a neighbor in the Brentwood Park.
What does he do?
He's in the real estate business.
And did you call him about this Bronco?
We talked about the Bronco.
And did he tell you he would call the police, call a commander on your behalf?
He told me that he might be talking to somebody from the police.
And as a result of that, you got a call?
That is correct.
Nobody came to your house on June the 12th to ask you what you had observed. Is that correct?
On June the 12th?
Of 1994.
That's Sunday?
Yes.
Sunday night, no.
What about June 13th? Anybody come to your house to ask you what had happened?
I left for Canada on a flight at 8 o'clock in the morning.
Did the police come to your house to talk to your wife, family, or inquire whether anybody at your residence had any knowledge of events that took place at the Simpson residence?
Not that I'm aware of.
Did you talk to your wife?
Yes.
Did she ever tell you that she had been contacted by the police?
Oh, but he's already testified he's not aware of any contact.
And I know you don't want to give your residence location, and we will respect that. Can you tell us where you live in proximity to Mr. Simpson?
I live within, certainly within a quarter of a mile of Mr. Simpson. Less than a quarter of a mile.
And up until the time that you called the police, well, you called your friend and the police called you back, no one...
I didn't, excuse me, I didn't call him, I was talking with him.
You talked to your friend, yes. And as a result of that, you were called by the Los Angeles Police Department. No one had come to take any statements from you, even though you live within a quarter of a mile of Mr. Simpson.
That is correct.
And what attempts did you make to report what you had observed to the police prior to January 25th of 1995?
I had made none.
What is your profession, sir?
I'm a self-employed private investor.
Do you have any legal background?
Yes, sir, I do.
What legal background do you have?
Oh, you can answer the question.
I have a law school graduate. I have practiced law in the state of California.
And is it your testimony that you would not know how to contact the police to report evidence that may be relevant to a murder case?
Sustained.
Did you tell, well, you talked to an officer by the name of Crotsley, C-R-O-T-S-L-E-Y, on January the 24th. Isn't that correct?
That is correct.
And at that time, are you aware that he reported that you did...
Sustained.
Have you ever reported to the police that you didn't know how to contact them, to give them information?
That never was an issue. The answer is no.
Let me show you a copy of the report that was prepared by Mr. Crotsley and see... yeah, this is what you just showed him this morning.
May we have that, please?
Counsel, I thought I directed you both to direct your comments to the court. All right, let's proceed.
Your Honor, may we approach, because apparently I do not have the complete reports.
He does not have the complete reports with him, Your Honor. There's a distinction.
All right. With the court reporter, please.
Well, while they sort this out, we'll break away for a moment. We'll be right back with more of our live coverage. We're back live now. Everybody seems to have the full copy. Well, in case you just now joined us, this is Mr. Charles Cale. He lived near O.J. Simpson. He said he did not see a white Ford Bronco at around 9:30 to 9:45 the night of the killings out in front of O.J. Simpson's estate. He's now being cross-examined by Robert Shapiro. Shapiro is challenging just why he never approached police.
I've taken a look at it, Mr. Shapiro.
Have you had enough time to read it?
I've read it. Excuse me.
Do you see if there are any errors or omissions in that report?
Well, as I told you before, I don't think there was an issue of my not knowing who to contact in the first paragraph.
What is the error in the first paragraph?
You said it says in the sentence that Mr. Jay Gardner stated that a friend, Charlie Cale, had information regarding the Bronco but did not know who to contact. I don't know what Mr. Gardner stated, but so I don't know whether that's, I guess that's somebody else's comment.
Let me just ask you on that point, then we'll move on. Did you ever tell Mr. Gardner that you had information but you didn't know who to contact?
No, I don't think in that sense I did. We discussed the issue that was in the fourth paragraph, 1, 2, 3, 4, where some comment had come up on the news that said that there was a...
What's the objection? You can finish your answer, Mr. Gale.
That had been reported in the news that someone was stating that the Bronco had been parked other than on Rockingham, and that it had been moved onto Rockingham by the police or by somebody, or that it had been changed in its location. And Mr. Gardner and I were talking, and I said I just had heard this, and he raised the question with me, and I said that's not the case, because I saw the Bronco on Monday morning when I went to the airport, and I had taken a walk the night before, and it hadn't been there. So that's how the whole subject came. So you ask also if I knew how to go get a hold of anybody in June. In June, there was never an issue that I was aware of about where the Bronco was or was not parked.
I take it that you know that there was a preliminary hearing in this case.
Yes, sir.
And I take it you know that that was televised.
Yes, sir.
Did you see any part of it?
I don't think I saw more than 5 or 10 minutes of the whole hearing.
Did you?
On the news, perhaps, but I did not watch it.
And did you see any news reports of any issue regarding a Bronco?
I saw news reports that indicated that there was a Bronco parked there and there was an issue of what was in it or on it or things of that sort.
So you knew as early as July of 1994 that the Bronco was at least an issue in this case, being a lawyer, did you not?
The Bronco was an issue. I don't know that it was an issue. I knew it was an element in the case.
And you're a reader of newspapers, are you not?
Yes.
You read about this case in the newspapers, did you not?
I read it in the newspapers, yes, sir.
And you were aware of something that's been referred to as a low-speed follow involving a Bronco?
I am.
Overruled at this point.
I'm familiar with that.
And so, as a lawyer, would it be fair to say that you could conclude that the Bronco was an issue in this case?
I don't practice law, but as someone who used to, I would say that the issue of the Bronco was in the case. However, there was nothing that I had seen or not seen about the Bronco that I thought was any issue until the latter part of January.
Being in close proximity to the Rockingham residence of Mr. Simpson, did you find it unusual that no one contacted you, whether you heard any unusual noises on June the 13th?
No, sir. Where we are is far enough away and with trees that I don't think that it would have been on anybody's mind to necessarily ask if we heard strange noises where we were.
What about vehicles that might be going by?
My answer would be the same.
What if you were outside your residence walking your dog, as you sometimes do? Would that be something that you think the police might want to know?
Sustained.
Are you familiar with the vehicles of all your neighbors?
Not all of them.
Are you familiar with all the vehicles that were parked on Rockingham when you went to the airport that morning on June the 13th?
I am familiar with the two that I saw, one on Ashford, which was the black and white, and the other was the Bronco, and to my recollection, there weren't any others parked.
There were no other vehicles on Rockingham that
Not
day?
that I recall.
What about the night before? What vehicles were parked on Rockingham?
On Sunday night?
Yes.
I saw none.
Have you ever seen any other Broncos at Mr. Simpson's residence or in the area of, strike that, in the area of Rockingham and Ashford, have you ever seen any other Broncos other than Mr. Simpson's Bronco?
I've seen other Broncos, yes, sir.
And you've seen them parked in many different locations, have you not?
Seen them parked on Ashford.
Have you seen Mr. Cowlings in the area of Mr. Simpson's residence?
Yes, sir, I have.
And have you seen his Bronco parked on Rockingham?
Not that I recall. I've seen his Bronco parked on Ashford, I know.
Is there something in particular about noting where a Bronco is parked 8 months ago that is important to you?
I don't really quite understand that question, Mr. Shapiro.
Have you watched any part of this case on television, any part of this trial?
Very little.
So you've watched some of it?
Very little.
What have you watched?
I've seen news clips from the news when I watch the regular news. That's really about all.
Have you seen any witnesses testify in this case?
I've seen saw Detective Furman briefly, and I don't know the detective, I don't even know his name, was there in the gentleman sitting behind counsel. I saw
indicated Detective Lang.
And I probably saw 2 or 3 minutes in total of Ms. Lopez.
And you were aware that all 3 of those people gave testimony regarding the Bronco, are you not?
Sustained. Be stricken, jurors to disregard.
I'm sorry, are you aware that Detective Furman gave information regarding the Bronco?
I really don't know what information Detective Furman gave about the Bronco, if he did.
About Detective Van Adder?
I did not see Detective Van Adder at all, even on on the news that I can recall, so I don't know what he talked about.
What about Detective Lang?
I don't remember anything that he talked about. I just remember seeing him.
Can you tell one Bronco from another?
That's a question I don't know how to answer, Mr. Shapiro.
Yes or no?
I don't think that's a question that's susceptible to answering yes or no. If you have two identical Broncos, I couldn't tell which was which. I can tell you that I recognized a Bronco when I saw it.
Did you recognize it as Mr. Simpson's Bronco, or did you recognize it as a white Bronco?
I recognized it as a white Bronco.
And the closest you got to the Simpson residence is where you put this reddish-orange marker on the Elmo?
That's my best recollection. Yes, sir. It was in that general area.
And it could have been before 9:30 that you were walking your dog, isn't that correct?
That's the best estimate I can give you, sir.
Well, you just used the term the best estimate and you're very sure.
Yes. I don't think those are inconsistent.
So you would, in your definition, your best estimate is being very sure of something.
When you have a period of time within certain parameters, I'm very sure of my estimate, that it's in that range of time.
Could it have been 9:25?
I don't think it was. Is it possible? I guess it's possible. I don't think so, though.
Do you walk your dog at a regular time every evening?
No, sir, I do not.
Do you walk your dog every evening?
No, sir, I do not.
Do you walk your dog every day?
No, sir. I walk the dog sporadically on occasion.
Did you walk, when was the last time you walked your dog before the evening that you've testified to?
I don't have a specific date. I walked it within that week, I know.
What cars did you see on Rockingham when you walked your dog within that week?
I don't remember that.
How far were the rear wheels of the Bronco, I think your words were, jutting out into the roadway? Have you heard that? Let me ask you this first. Have you heard that term used in this case by anyone else?
No, sir, I have not.
Have you read that term in any of the newspaper articles?
No, sir, I have not.
Have you seen it on any newspaper clippings? Any news clippings?
No, sir.
How far was the rear end jutting out?
I would say, again, I was driving by in the car, and I was, say, appeared to me to be 18 inches from the curb, with the nose, the front right wheel closer to the curb.
Now, you're aware that there is a concrete gutter area and then asphalt on the street, is that correct?
Yes, sir.
How wide is the concrete gutter area?
I don't know. 6, 8 inches, I would assume.
So the tires then were more than 10 inches to a foot, the rear tires on the asphalt?
I really can't say. Again, we were driving by. I looked and I saw that the car was out at an angle which wasn't parallel to the curb. I didn't stop and look.
You just gave testimony that was 18 inches away from the curb.
I said that was my estimate. I believed it looked like it was about 18 inches from the curb. The nose wheels were close against the curb, and the rear wheels were out from it.
And if the concrete area is 6 to 8 inches, then by simple, isn't that what you testified?
I guess when you say concrete, you mean the curb comes down onto the street?
Is there a concrete gutter area on Rockingham?
There's a curb, and then the curb necessarily makes a gutter when it, I guess you'd say, when it comes to the street.
And my question to you is, how wide is the gutter?
Oh,
you understand the question?
I really don't, Your Honor.
Describe the curb, the gutter area, and the asphalt on Rockingham adjacent to the Simpson property.
I believe that there is a concrete curb. The curb goes down to the street and then out some inches, which I think is, what I said, 6 to 8 inches from the vertical. And at that point, the asphalt starts.
So your testimony then is if the car is 18 inches out onto the asphalt.
18 inches from the vertical curb.
Are you from the vertical curb?
Yes, sir.
So that it would be on about 10 inches of asphalt.
Those numbers, yes, sir. I'm not saying that well, if you take the numbers, that would appear to be correct.
And those are the numbers you've given us?
That's the numbers I've given.
Were you driving the car on the way to the airport?
No, sir, I was not.
But you were on the passenger side?
That is correct.
Did you see any other vehicles in the area of Rockingham and Ashford other than the the one black and white police vehicle and the white Bronco?
I have no recollection of seeing any others. It really wasn't an issue. I mean, we were going to the airport. I saw the police. I said, let's go straight. I saw the Bronco, and we continued.
You saw the police or you saw a police vehicle?
The police vehicle, the black and white.
Did you see any policemen?
No, sir, I did not.
Did you see anyone guarding the Bronco at 7 o'clock in the morning?
No, sir, I did not.
Did you see the Bronco cordoned off in any way to look like it was being secured?
No, sir, I did not.
Did you see the house cordoned off as if it was a crime scene area?
I don't have any recollection of that.
With the court's permission, put exhibit 1037 on the Elmo.
Well, they may be putting up the photograph of the white Ford Bronco, a photograph taken the morning of June 13th, and it's from the rear aspect, and you can see just how far away it is from the curb.
I want to direct your attention to the photograph that's being displayed.
Yes, sir.
Do you recognize that vehicle?
That appears to be the white Bronco parked on Rockingham.
Do you know who owns that vehicle?
I believe that that's Mr. Simpson's vehicle, but it's I'm not positive of that. I haven't seen the registration. It's the white Bronco.
And what is it about that vehicle that leads you to believe that it's Mr. Simpson's from this photograph?
Well, it appears that that's Rockingham, and the car is parked with the rear wheels out. That's all I can say.
Well, how does that identify it as being Mr. Simpson's Bronco?
Well, that's the white Bronco, whatever the white Bronco was that I saw.
And would you say that the wheels are in the same position you saw as you were driving by as a passenger on the way to the airport?
That looks correct.
And you would say that the back tire is 10 inches onto the asphalt?
Well, looks like the outside part of the tire is a couple of inches on the asphalt, and the front tire is closer in.
And you describe that as jutting out and being very unusual.
I think I said it jutted out.
Would you describe that as being unusual?
I don't think that's a paragon of parallel parking, but is it parked illegally? I don't know. The front wheels are in and the back wheels are out farther. That's what I saw when I was on the other side.
And how much time elapsed when you passed by that vehicle?
What point?
at the time you were on the way to the airport?
We slowed down when we came to Ashford, thinking we would turn onto Ashford. I said, let's go straight. So we passed it going, accelerating from 5 or 10 miles an hour to 20 miles an hour, 25 miles an hour. We just drove by in passing. Probably saw it a couple of seconds.
Who was driving you?
A young man by the name of Joel.
How do you spell that?
Joel.
And did you mention anything to this individual about walking your dog the night before? Oh, well.
Not about walking the dog. I mentioned to him, I said, that's strange. The car is parked there, and it wasn't last night.
When was the last time you talked to this man?
Probably yesterday.
He works for you?
He does on occasion, yes.
In what capacity?
He drives.
Your chauffeur?
I wouldn't have it raise it to that dignity in the sense that he's not there all the time, but he just drives and does errands.
Are you aware that Mr. Cowlings has a key to the Rockingham gate?
Sustained.
Have you ever seen anybody enter the Simpson residence from the Rockingham gate?
I don't know that I've ever seen anybody enter from the Rockingham gate. I've seen people come out from the Rockingham gate. I don't recall that I have or have not.
Have you ever seen Mr. Cowlings enter from the Rockingham gate?
No.
Have you ever seen Miss Barbieri enter from the Rockingham gate?
I have not.
Do you know who she is?
I only know by name and reputation. I don't know her personally.
By name and reputation?
That she was a friend of Mr. Simpson's.
How do you know that?
I've heard that.
Where?
People have talked about it.
Certainly.
Are you aware that Paula Barbieri has a white Bronco?
No, sir, I don't know anything about Miss Barbieri other than what I just said.
You are aware that Mr. Cowlings has a white Bronco, do you?
Yes, sir, I am.
And do you know that the only way that an outsider can gain entrance to the Rockingham property, to Mr. Simpson's residence, is through the Rockingham gate?
Excuse me? Would you?
Sustained.
Is there anything in particular about the Simpson residence that causes you to focus on it?
Well, it has a...
Oh, well, you can answer the question.
Yes. Mr. Simpson is a celebrity. Certainly I think one of the most well-known people in the neighborhood. Also, it's on the corner where you either going south or, either going west or east on Sunset. If you're going to go to Sunset, you go by Mr. Simpson's house. It's distinctive. It's Christmas lighted brightly. I mean, I think it's a focal point.
And you said it was lighted brightly. So you can, by walking by, see that house and focus in?
I said at Christmas.
Oh, at Christmas.
Yes.
What about normally? Isn't there a halogen light on the corner of Ashford and Rockingham? Street lamp?
There's a street lamp at the corner of, yes, sir.
And doesn't that illuminate the front of the Simpson property?
Not the light I know there are lights on the property.
Oh, well, he can answer.
There are lights on the property. There's a blue, if that's a halogen light, and there's some other lights on
The property is very well lit at night, is it not?
Beg. Want to rephrase the question?
Are you aware of the lighting on the property at night?
What you can see from the street.
And what can you see from the street?
There's one of the trees I know is uplit on Ashford with I'm not sure if halogen is the blue light, with a bluish green light as I recall. There are some lights that you can see around the, again, that there is some light around the driveway, and that's really all I can recall, that there's some lights in the back by the pool area sometimes that you see.
On the night before you left for the airport, did you see a limousine in the area of Ashford and Rockingham?
No, sir, I did not.
If there was a limousine parked outside the Rockingham gate at about 9:30, would you have been able to see it?
Oh, well, I believe so.
And if there was a limousine driving up Rockingham to Ashford, would you have been able to see it?
Oh, well, you can answer the question.
I believe if it had had its headlights on, I would have.
And if there was a limousine parked across the street from Mr. Simpson's residence on Ashford at 9:25 to 9:35, would you have been able to see it?
Sustained. That's the point of that question.
Regarding a limousine, did you ever see any limousine parked along Ashford that night while you were walking your dog?
Overall.
I did not see a limousine parked on Ashford when I was walking the dog.
And you're a pretty meticulous person, and you're very, very observant of things, are you not?
I don't know how to answer that. I don't know. My wife doesn't think I'm as meticulous, perhaps.
Join the club.
I try to be observant when I'm out walking at night.
Did you see any people walking in the neighborhood when you were out at 9:30?
No, sir, not that I recall at that time.
You recall seeing a limousine driver outside of Ashford smoking a cigarette?
No, sir.
Hold on. The jury's heard the testimony of both witnesses. They know that they can put the two testimonies together. All right.
About a Bentley. Did you see any Bentley at the Rockingham property at 9:35?
No, sir. I didn't look into the property.
Pardon?
I didn't look in the gate.
Did you see any small foreign vehicle on Ashford at all that entire evening when you were out?
I did not see any on Ashford, no, sir.
You didn't see any car. Did you see a Nissan Z on Ashford?
I think I said before, I don't recall seeing any cars on Ashford.
When you reviewed this report that I've shown you, and you see where it indicates that...
Objection.
Did you tell the police officer...
Sustained.
And I would ask Mr. Shapiro to the record to give me an opportunity to see what he intends to read to the record.
Counsel.
Thank you. Mr. Cale,
yes, sir.
Did you previously tell a police officer who took a report from you that you went to bed at 10:30 that evening?
Objection. That mistakes the report, Your Honor.
I told the police officer that I recall getting home to try to get in bed sometime after 10, between 10 and 10:30. It says here that I said 10:30 because I wanted to be in bed early because I had to get up early the next morning. I don't know whether I told him I was in bed at 10:30 or 10:15 or 10:10.
Do you know what time you were in bed?
I know I was in bed by 10:30. I think I was probably in bed earlier than that, actually.
Are you as sure of the time you were in bed as sure of the time you were walking your dog?
I'm sure that I was in bed between 10:15 and 10:30. I think I may well have been in bed before 10:15, but I wasn't in bed at 10.
You would agree that it's very difficult to be precise on times unless you're looking at a clock for a specific reference. Isn't that true?
I think that that is true.
Thank you. May I just have a moment?
The last picture that was shown of this witness was of the white Ford Bronco taken by police the morning of June 13th, 1994, and it's not the only picture taken. From the defense perspective, it's the preferred picture. From that angle, it doesn't look as though the Ford Bronco is jutting out, as the testimony has been, very far from the curb. There are different photos that sort of give a different perspective. And that prosecutors have a tendency to use those photographs because they do seem to reflect the jutting out.
Putting up People's 157?
Yes.
That's 157A. Yes. 157A. Madam Reporter. 157A, this exhibit.
Let's see if we can get it up on the Elmo. Can we put that on the Elmo, Your Honor?
It appears to be.
On the big screen here? There we go. Mr. Kale, how far is your house from the red line you've drawn?
Objection. You can tell us in distance. Oh.
Show the court the report.
Well, what I'm interested in probably is how long it would take to walk from his yard, walking his dog to that location.
That's precisely the point, Your Honor.
Knowing the particular idiosyncrasies of this particular dog.
Walk with the dog, it would take me 3 or 4 minutes.
What's the distance?
Depending upon what the dog was doing.
What's the distance?
I could, without the dog, I could walk it in probably 2 minutes.
What is the distance in, you gave us before a distance of 1/4 mile from your residence to the Simpson residence. What's the distance from your residence to the red line?
Well, as I said before, I live within 1/4 mile. It's less than 1/4 mile. I mean, I don't know, Your Honor, do you want me to tell him in numbers of specific yards? And
No, I think walking it in 2 minutes is the material issue.
I mean, it's less, you know, with the dog, it could be, again.
Would you trace the route that you walked your dog and directing the arrow on the Elmo? Please.
That's not particularly relevant at this point. The route as to how he got there. The issue is how far down Rockingham did he get? How close to the Rockingham residence in the Bronco did he get? That's the issue.
Would you indicate, thank you, Your Honor, on the Elmo where you believe, where the Bronco was when you saw it on the 13th?
Is this the full view, Mr. Harris?
Again, it's difficult because of the definition and the angle here, but the closest I would say, and again, I don't know where the driveway comes out, but you see on Rockingham, just above the border of the photograph, there are looks like two vehicles, sort of whitish vehicles. And it would be, again, I'm having a hard time just getting the exact reference to where the driveway, the Rockingham driveway would be, but it would appear to me that it would be the southernmost of those two vehicles. That's the general location.
And how far in distance is that location from the distance that you walked your dog closest to the Simpson residence?
The closest I got was in the general area of that red line, and as I said before, I thought it was probably about 60 yards.
Have you ever measured that off?
No, sir, I have not.
Is that just an estimate, just a guess or an estimate?
That would be my estimate.
So we're precise, if you could direct Mr. Harris to circling the vehicle where you believe the Bronco was.
Well, subject to my problem of not being able to see where the line of the driveway is, and it was parked immediately, you know, to the north of the driveway, it appears to me, with that little caveat or exception, that it's the location is the lower of the, I see this little mark is marking, I would come down a little bit, and now that to the right of that. It's, you know, now up onto that vehicle. That vehicle, I mean, I can't really even tell if that's a vehicle or a truck, or I don't know what it is, but it looks like there's something parked there, and that would be where I believe the Bronco was parked the next morning.
Well, is this a correct indication of where you're trying to establish
that location? I'm trying to, yes, sir. And that's, I'm assuming that that is to the north of the driveway, the Rockingham driveway. I can't see the Rockingham driveway on the photo.
Did you receive a call from a member of my office, Mr. Pat McKenna?
I received a call from somebody at your office whose name McKenna sounds correct. I didn't take the name down, or didn't get.
How many did you talk to him?
I talked to him. Yes, sir, I did.
On how many occasions?
I talked to him once, just very briefly.
What date was that?
That was the day before yesterday, I believe.
You sure of that?
I believe so.
I'm just asking you, are you sure of that? Or are you just guessing?
No. Today is Friday. He called me Wednesday afternoon.
And where were you when he called you?
I was at my office.
And did he ask to have an opportunity to speak to you about your observations?
He said that he worked for the defense team and was an investigator, and he had seen my name from the district attorney's list, and he hoped to have a chance to talk to me at some point. I told him that I was leaving then. I didn't feel very well, and that we could talk later.
You could talk later?
We did not talk later.
But you told him you could talk later?
Let's call back later.
And did you tell him when to call back later?
You know, I said I'm leaving now. I said let's talk like maybe next week.
Next week?
I think that was what I said to him.
After your testimony?
I did not know at the time that I was going to be testifying then.
Did you have his number?
No, sir, I did not.
Did you have my number?
I received your number last night.
Did you receive my home number?
Yes, sir.
And did you get a request that I would like to talk to you before you testified?
Yes, I did.
Did you call me back?
No, I did not.
Nothing.
Mr. Darden?
Mr. Keller, is there some reason that you did not call Mr. Shapiro back last night?
Well, I received a call from a mutual friend sometime after 8 o'clock in the evening I had really not been feeling well, as I had explained. And I did not know that I was going to be necessarily testifying today. And I didn't really think at 8:15 I needed to call him back. I didn't feel up to it.
And did you attempt to explain this to Mr. Shapiro this morning?
Yes, sir, I did.
In fact, we dragged you out of your sick bed today, didn't we?
Yeah. Yes.
You've testified that you were out on Rockingham around 9:30 and 9:45 p.m. Sunday night. Is that correct?
Yes, sir.
Okay. And so if a limousine had parked on Rockingham at 10:22 p.m. Sunday night, you wouldn't have seen that limousine, would you?
I was in bed. Don't know that I was asleep, but I was in bed.
Okay. And if the limo was at Rockingham at 10:39, you would not have seen it?
Same answer.
And you did give a statement to the police in late January, is that correct?
Yes, sir, I did.
And when Mr. McKenna, the defense investigator, contacted you, it was just this past Wednesday, is that right?
It was Wednesday in the latter part of the afternoon.
And that will be March 29?
Yes, sir.
Okay. And does the statement there in front of you, the one Mr. Shapiro gave you, indicate the date of your interview?
January 25, 1995.
So you spoke to the police on January 25, and Mr. McKenna contacted you on March 29.
Yes, sir.
Have one moment.
Certainly.
When you spoke to the police in January, did you give them the approximate time in which you were out walking the dog?
Yes, sir.
Okay. Did you tell them about the Bronco not being there?
Yes, sir.
Thank you, sir.
Mr. Shapiro?
When you were walking your dog, sir, did you see a Bentley automobile driving up Rockingham?
No, sir.
If a Bentley had been driving up between 9:30 and 9:45, were you in a position to see it?
It had its headlights on and was up that far to the corner. I would have been, yes, sir.
You're familiar with what a Bentley looks like?
Yes, sir.
Have you seen a Bentley vehicle at Mr. Simpson's residence?
Yes, sir.
Did you see that vehicle driving up between 9:30 and 9:45?
No, sir.
When were you told by any member of the district attorney's office or prosecution that you would be required to come to court today?
I was asked yesterday to come this morning to meet with Mr. Darden. I did not know that I was going to testify till I got here.
What time were you asked yesterday to come to court?
It was in the morning.
Had you received a subpoena to come to court?
Yes, sir.
And what is a subpoena?
It's a order of the court to appear.
For what purpose?
To testify.
As a witness?
Yes.
So when you got my inquiry to kindly call me back at 8:30, you knew you were going to be a witness today in this courtroom, did you not?
No, I did not.
You didn't have the subpoena?
I had been subpoenaed some weeks ago. I had been told that I was on call, that they didn't know whether they would use me, and that they wanted to have me meet with Mr. Darden, at which time there would be discussion or decision made by Mr. Darden whether, when, and if I would testify.
No,
I met with Mr. Darden this morning.
You knew court was in session today, did you not?
I think so.
And you know Mr. Darden's one of the lawyers in this case?
Yes, sir.
And you know he's in court every single day?
I guess he is in court every day, yes, sir.
And that your wife was told by, at my request, that you were subpoenaed as a witness by the district attorney for today? She told you that, didn't she?
I'm sorry, I didn't follow the question.
Didn't your wife tell you yesterday that you were going to be a witness in this case today?
No, I don't think my wife told me that.
Well, sir, as a lawyer, having received a subpoena, being put on call, being notified that you were to come to court, and to see Mr. Darden, who has been in court every day since this case has begun, did you come to the conclusion that you were going to be a witness in this case, sir?
I thought there was a chance that I would be. I did not know that I would be a witness today.
And knowing that, you still did not return my phone call, did you?
I received your phone call, sir, at 8:15. I had been in bed much of the day, and I thought at that point that there really wasn't incumbent upon me to call you back.
And I also...
I did make myself available here to you this morning.
And I also told you this morning that if you were not feeling well, that we would have no objection to recessing this case and you coming back when you were feeling fine. Isn't that correct?
That is correct.
And at that point in time, you said you'd like to talk to Mr. Darden, didn't you?
Yes.
And I was never given the opportunity to talk to you until you took the witness stand. Isn't that correct?
Objection, Your
Honor. I don't...
Objection.
Sustain. For Fred's question.
Did you allow me to talk to you after that conversation?
Mr. Shapiro, I was sitting there. I expected that you would come back. You didn't. I talked with Mr. Darden about whether or not he was going to put me on now or whether I should come back later.
And what did Mr. Darden tell you?
He said he wanted to put me on now.
And did you tell him that you were feeling ill and that you shouldn't be put on?
I told him I didn't feel particularly well.
Did you tell him you'd rather not testify today? You'd rather take Mr. Shapiro's suggestion and come back when you were feeling better?
I'd rather not testify at all.
Mr. Darden, anything else?
Mr. Kell, I have nothing further, sir.
All right. Mr. Kale, thank you very much, sir. You're excused. Thank you. All right, let me see counsel without the court reporter, please.
We're live here at the Criminal Courts Building where this is taking place. A witness who was a bit of a surprise, I suppose, though now we learn that the defense did know about him in January. And I suppose how you look at this witness depends upon where you sit. And from the defense table, Michelle Levine, they sit there and their view of it is that this is a witness who really didn't want to talk to them. And if you're sitting at the prosecution's table, it's a witness who simply wasn't contacted by the defense for the better part of 2 months.
Oh, I agree. And we talked a little bit as the testimony was being heard live. The fact that this report was taken by a district attorney investigator back in January of this year. Certainly, Mr. Shapiro or the persons working with the defense team had ample opportunity prior to Wednesday of this week to contact this witness and ask him questions. And for Mr. Shapiro now to indicate that this witness was not making himself available, it seems silly, but that's just one tactic that they're using.
Let's take a look now. We're back live.
Ladies and gentlemen, we are going to, I'm advised that we are going to shift the focus of the case now to the collection of the physical evidence in the case. Before we do that, I need to look at some of the exhibits that are going to be presented, and I need to make some rulings as to what will be presented to you during that phase of the trial, since we're going to be shifting gears here. I anticipate that that will take me a couple hours to do, so I'm going to cut you loose for the morning session. Please remember my admonitions to you. Do not discuss the case amongst yourselves, form any opinions about the case, don't conduct any deliberations, and do not allow anybody to communicate with you with regard to the case, and I'll see you back here Monday morning, 9 a.m. All right, we'll stand in recess as far as the jury is concerned, and as soon as they're cleared, we will reconvene for the evidence determinations.
And so delayed for more than an hour this morning, and now really just a brief witness, Charles Cale, but to prosecutors, an important witness, so they have perhaps accomplished something. Michelle Levine, how do you assess this witness?
Well, I think they have accomplished something. What it does is you want to leave a week on a strong witness. I think had they entered the phase of the collection of evidence, that you might have seen the testimony sort of bogging down somewhat in the in that kind of technical sense. What this does is it leaves the jurors once again with the idea that the Ford Bronco was not where the defense team is saying it was or wasn't at any given time. I think it interesting that this witness mentioned having heard testimony of a witness with the last name of Lopez. I don't think he said Rosa Lopez, but I do think he said Lopez. And this obviously is a witness that was not heard and may not be heard by the jury. And you wonder whether or not the jurors go back scratching their heads and wondering who is Lopez and why didn't we hear from this witness.
Indeed. They have heard, of course, the name Rosa Lopez before in court because it has been brought up by the defense that Detective Mark Furman may have interviewed this witness, but it's been rather cryptic. And these jurors certainly don't know half of what everybody else knows who hasn't been sequestered in this case, which comprises just about everybody else. We're going to break away for just a moment. We'll be right back. Welcome back. We do expect court to resume momentarily. We do have an opportunity to sort of look back on this last witness, and it's always interesting, not just the content of what witnesses Michelle Levine have to say, but certainly their sort of attitude, their demeanor, their reaction under cross-examination. Is a world of difference between Rosa Lopez and an Allen Park, and perhaps you could say the same of this new witness, Charles Cale.
Absolutely. The manner in which somebody relates something when they're on the stand adds very much or detracts very much from their credibility, and whether or not the jurors are going to put great weight in what they say and the evidence that they bring forth to the jury. In this instance, you have a man who could have tried to make himself appear like the poor witness because he wasn't feeling well. He did not do that. It wasn't until cross-examination that was even brought out. So you have somebody who is doing the best he can, is how I view it, and is not engaging in any repartee or argument with defense counsel, but simply stating what he saw to the best of his ability.
Yeah. And although Mr. Shapiro tried to now and again, it seemed, provoke him a little bit and try to get him to step all over himself with inconsistencies, the witness simply stuck to what he said. He remembered, and only that. But Dan Abrams, let's go out to you. You've been inside the courtroom, and this is a witness who said a great many things about the Ford Bronco, and he also brought up a name by the name of Rosa Lopez. He said Lopez.
Well, that's right. He said that he had seen part of 2 to 3 minutes of Miss Lopez's testimony. This is now the second time these jurors have heard about the fact that Rosa Lopez testified. Again, remember, this was on videotape. The jurors were not present. And so for the second time now, the first time with Detective Mark Furman referring to Rosa Lopez's testimony, now we have a second witness referring to Rosa Lopez's testimony. These jurors must know there is something up with someone by the name of Rosa Lopez. We should also point out, though, that Johnny Cochran did mention her by name in his opening statement.
Right. Dan, I'm sorry, we'll have you stand by for just a moment. It looks like the attorneys are now talking to the judge. Let's go live.
Case, Johnson case concerning a match. And counsel has deliberately misrepresented to this court the import of the terminology and the exchange that occurred in the course of the hearing from the Christopher Johnson case. The unfairness of that is that this court and the publicity that generates from every hearing that we have has now been completely falsified in terms of what actually transpired in court. Counsel now proffers to the court a mere few pages from a transcript seeking to establish the basis of the misrepresentation they have made to this court. I would ask that the court refuse to accept the mere few pages they have proffered and insist on the entire transcript.
Let me, forgive me for interrupting you, but I have a dislike of excerpts from transcripts as well. I've already ordered the complete court file.
Great.
Mrs. Robertson advises me that the complete transcript at my request has been delivered to the court.
Great, thank you, Your Honor. The other point I wish to make to the court in advance
Which means I get to read a whole lot more stuff.
Yeah, even though, which is exactly, I know what you need to do.
This weekend, yes.
Exactly. You have volumes, I know. And let me assist the court in that regard when you see it. The Christopher Johnson matter was a paternity match. It was a murder case without a body.
I noted that.
So when we discussed the issue of a match, the witness said, well, I can't say there's a match because I don't have a known sample from the victim. We have no body of victim. All we have is a blood stain at a crime scene, and we're seeking to establish whether that blood could have been the blood of the son of this father, the husband of this mother or wife, the father of this child, and the sibling of this sister. I mean, so it was a paternity match we were talking about, and that's why the witness was saying, we can't say a match because we don't have something to match it to. We can only say that this blood is consistent with the being a relative of these people in this regard.
All right, Ms. Clark, I don't want to litigate that issue now.
Okay. But it is a totally separate situation from what we have here. It's not the same situation.
In reading the excerpt, enough interesting things came up, specifically the paternity issues and what the test was, that caused me to order the complete file, which I've done.
Okay. When would you like me to be prepared to address this matter, if ever?
Obviously, we'll have to breach that issue sometime when we get into the DNA testing.
Okay.
But I've got it. I'll look at it. We'll see what's there.
Okay. Thank you.
All right. Thank you. All right. Now, the issue is the counsel, you wanted to have a hearing with regards to the videotape.
Yes, Your Honor, that's true. If we can't finish today, we can come back and finish Monday morning if Your Honor wants us to.
No, I'd like to finish today.
Right.
Unless you have some other commitments, but let's finish this issue.
I have no commitments, but let's see what we can do.
All right.
It's about 5 minutes of our time. I'm trying to point out. We're ready to proceed. I would ask there are 4 witnesses we anticipate calling. Are they here?
They're in a nearby waiting room.
They're where?
In a nearby waiting room. Who was that you wanted to call first?
I would like to exclude the witnesses. I call Ms. Atkins first. Atkins.
All right, and while we're waiting, during the course of the examination, Mr. Cole, I think, Mr. Shapiro, you neglected to mark one of your exhibits.
Yes, I did, Your Honor, and I believe the report marked the photograph that was shown to the witness as Defense 1067.
Mrs. Robertson, 1067. All right, this is the photograph by Mr. Cale circled the automobile that appears in the lower left-hand corner of the photograph.
That's correct, Your Honor.
All right, so marked.
Thank you very much. Thank you.
We're going to break away for a moment, and we'll be right back with more of our live coverage.
Hello, I'm Beth Harris with a Court TV News Break. A federal judge has issued an injunction today restoring salary arbitration and free agent bidding. The National Labor Relations Board made the request earlier today in Manhattan Federal Court. The players who have been on strike for almost 8 months have said they would end their strike if an injunction was ordered. Major League Players Association Chief Donald Fair said he hopes the decision will lead to a short spring training followed by a regular season without replacement players. U.S. Air and Boeing have settled a lawsuit filed by the families of 2 passengers who died in a September plane crash near Pittsburgh, Pennsylvania. The U.S. Air Boeing jet collided into a hillside, killing all 132 passengers on board. The cause of the crash is still under investigation. And a federal judge in New York has set a July trial date for Lemrick Nelson. The teenager is accused of violating the civil rights of Hasidic scholar Yankel Rosenbaum. Nelson was acquitted of murder charges in a state trial accusing him of fatally stabbing Rosenbaum during the Crown Heights riots in 1991. That's the Court TV News. I'm Beth Karras.
What if you could save up to 50% off on replacement contact lenses?
Save 50% on my contacts?
Maybe more, and you can have them delivered to you the next day.
What's the catch?
No catch, just call General Lens Corporation. General Lens is America's favorite replacement contact lens service. Their professional staff knows contact lenses. With just a quick 2-minute call, you can get any name brand lens delivered overnight to your home by Airborne Express. And you get the exact lenses your doctor prescribed or your money back.
You know, my doctor said it's better to replace my contacts more often to avoid protein buildup. Now I can afford to.
If you call and order replacement lenses now, General Lens will send you a free pair of UV sunglasses and a cleaning kit with your first order.
Let's see, I save up to 50%. It's easy to order. Next day delivery, a money-back guarantee, and free sunglasses? How do I order?
For the lowest prices on replacement lenses, call 1-800-680-LENS. General Lens Corporation, America's favorite source for contact lenses. That's 1-800-680-LENS.
It was probably somewhere around.
On the witness stand being questioned by Johnny Cochran is David Atkins, who is a principal photographer with the LAPD. He videotaped the search of O.J. Simpson's estate June 13th.
No, I don't.
So everything you're testifying about now is from your independent recollection?
That's correct.
You've not been able to refresh your recollection on any kind of documents, right?
Relating to what matter?
As to the time you got the call, as to the time you arrived at Rockingham.
That's correct.
You're testifying to your memory. Is that right?
That's correct.
All right. So your best recollection is that you and Mr. Ford went out to Rockingham together and arrived there at about what time?
Between 3 and 3:30.
All right. And when you arrived there, did you have occasion to meet with any detectives?
Yes.
And were you present when any instructions were given as to what you were to shoot at Rockingham?
Yes.
Okay. Tell us about that. Who did you talk to, first of all?
When Mr. Ford and I first arrived, we were met by Detective Harper, and he explained that they wanted an overall of the exterior and interior shots. And then he handed us off to Detective Harrell.
All right, so your first conversation was with Detective Harper, and what did he say about the exterior shots he wanted you to get?
Nothing specific. He just requested they wanted general photographs of the exterior of the home.
All right, when you say photographs, did he want a video of the exterior of the home?
That's correct.
And was Mr. Ford in your presence when those instructions were given?
I'm not sure.
You recall that you were there?
Yes.
And would you assume that since Mr. Ford was going to do the shooting, that he was also there to hear this?
Probably. Yes, I would assume he would be there somewhere.
Right. And then after your initial conversation with Detective Harper, you then were turned over to Detective Harrow, H-A-R-O, right?
Correct.
And where was Harrow when you first talked to him on that date?
I don't specifically recall, but I think it was outside the front door of Mr. Simpson's home.
Did you have a conversation with Detective Harrow?
Yes.
And who was present during that conversation?
To the best of my knowledge, it was just Mr. Ford and myself.
All right, and again, tell us about the conversation with Mr. Harrow.
It was a reiteration of the first instructions that they would like to get videotape of the exterior as well as the interior of the home.
All right. And any other instructions at that time?
No.
Were you told at this point why you were doing this? Why were you shooting? Why were you about to videotape the Simpson home?
I don't recall if specific instructions were given to us as to why we were photographing it. My understanding as to why we were photographing it was just to document the way that the home looked at this point in terms of what vehicles are there, what landscaping is there, and on the interior, what items are sitting where in the home.
Was it kind of a record of inventory?
Pretty much, yes.
And did you also, were you also told that you wanted to get, make a record of everything seized by the police pursuant to a search warrant?
No.
Did you not indicate that this morning? That was one of the things that you indicated that you were, that was your impression?
No.
You did not indicate that in the conversation this morning?
No.
Did you indicate this morning that one of the purposes of your doing this video was for civil liability purposes?
That's correct.
Tell us about that.
There have been cases in the past when police officers have had an opportunity to enter a home or had an occasion to enter a home when claims have been made against the police department, such as things were missing, there was an expensive vase there, things of that nature, things were ruined. What we like to do is come in and document the condition of the home at that time so that if it was ever needed again, we could show that that was there or was not there.
All right. So that's the civil liability aspect. Were you also, did you also indicate this morning that one of the purposes of your shooting the video was to help the detectives to see where items were recovered?
No, I did not.
All right. You had a conversation this morning with the gentleman to my immediate left here, Mr. Scheck and Mr. Neufeld, is that correct?
That's correct.
After you talked to them, did you have occasion to talk with some member from the district attorney's staff this morning?
No.
You not talked to anybody from the DA's office?
When you say talk to them, more than say hello or casual conversation?
Sorry. Talk to them about your testimony at all?
No, I did not.
Okay. And so do you have a recollection that you indicated this morning that you said to Scheck and Neufeld that your recordation, your video recordation was to help the detectives see in the future where items were recovered?
No, I did not.
All right. A second there. Did you ever indicate to either Messrs. Scheck or Neufeld that you wanted to make a video record so if things weren't seized and you wanted to go back at a future time and seize them, you'd have an actual record of where these things were? Did you ever indicate that?
I may have said something along those lines.
Well, what was your understanding back on June 13th with that regard?
The reason that we photographed the inside was, as I stated, mainly was for the civil liabilities issues.
Yes.
Sometimes if a detective is reviewing this videotape and notices something else, they may want to revisit that location.
All right. So it provides some help for the detectives in later search warrants if there's to be one, or where things are in the residence, right?
There's a possibility that the tape could be used in that way, yes.
All right, sir. Now, you've had occasion to see that tape, have you not?
I have not seen the tape in its entirety, no.
All right. Did you see it being shown at least partially this morning?
Yes, I did.
Is that the first time you've seen it?
Yes, it is.
Since June 13th?
That's correct.
All right. And the man who actually shot the tape, as I understand it, is Mr. Willie Ford, is that correct?
That's correct.
All right. And he's here this morning also?
He is.
All right. You remember what kind of camera Mr. Ford was using on that date?
I'm sorry, would you repeat that question?
You remember what kind of a camera Mr. Ford was using on that date on June 13th?
Yes, it was an RCA VHS camcorder.
Camcorder? And is there a time and date on that particular camera?
Yes, there is.
All right. And prior to this date of June 13th, 1994, had you had occasion to video other crime scenes in your capacity in the photo lab at the LAPD?
Personally video myself?
Or, no, been present when they've been down to your lab, had occasion to do that?
Sustain Fred's question.
No, sure. There have been other occasions when individuals who work for you in the lab of the LAPD have been asked to video crime scenes?
Yes.
Okay, how many occasions in the last year?
Fewer than 6.
And have you had occasion to go on any of those video shoots?
Yes.
And under what circumstances does the LAPD use those video shoots at crime scenes?
I would really have no knowledge as to how those are used.
All right, but fewer than 6 meaning how many? Your best estimate.
That's a pretty close estimate, fewer than 6.
But what does that mean, though? Fewer, is that 1, 2, 3, 4, 5?
All right, 4.
What's your best estimate? 4?
4.
All right. And how many of those 4 had you been out on?
2.
And you don't recall any particular reason why those 4 were chosen, or there were video shoots on those 4?
We were requested to respond with video, and that's the reason, as far as my level is concerned, that we videotape those.
Would I be correct in assuming that back in June of 1994 you did not respond to every crime scene in Los Angeles to video shoot, right?
That's correct.
Okay. Did you ever, in connection with this case, ever go to the Bundy scene and do any video shooting?
I went to the Bundy location. We did not do any video.
And why didn't you do it there?
We were not requested to do so.
And so whoever was there, a detective in charge at Bundy when you got there?
Was there a detective in charge?
Yeah.
Yes.
Who was that?
The person that I spoke with was Lieutenant Rogers.
Okay, Lieutenant Rogers, and he never asked you to shoot at Bundy?
That's correct.
Why were you over there?
I was there to relieve Dieter Rokar, to have a relief for Gary Goodwin out to that scene.
Does Rokar work in your unit?
Yes, he does.
You supervise him?
That's correct.
And did Rokar have a video camera with him that morning when he was at
We're kind of far afield on this issue.
I'm almost ready.
Well, we've got about 8 questions on Bundy that's irrelevant to this issue.
Right. Allow me just this.
2 more.
Thank you.
This is in the way of discovery.
Certainly.
Sure.
No, not exactly, Your Honor. Let me look it up. With regard to Rokar, did he have a video camera that morning?
No, he did not.
All right. But he did work for you at that point?
That's correct.
All right. And there was no shooting of Bundy?
No video shooting?
No video shooting of Bundy.
That's correct.
Well, I have nothing further of Mr. Atkins at this point, Your Honor.
Ms. Lewis?
Thank you, Your Honor. Just briefly. Mr. Atkins, is there a policy of the Los Angeles Police Department, which you're familiar with, which allows detectives at their choice to either have still photos taken or videotapes taken of locations where search warrants are executed?
I don't know of a specific policy, but that is my understanding.
And what is your understanding with regard to search warrants being executed and possible civil liability? Do you have one in that regard?
In terms of shooting video and photographs?
Yes.
I know that they're highly desirable.
Why is that?
For purposes after the fact, as I explained before, to show the condition of the residence and the condition of art objects that may or may not be there.
And was that your understanding of the purpose for your presence at Rockingham on that particular occasion, was to document the location of items and what those items look like in case of future civil liability?
That's correct.
When you were at the Rockingham residence, accompanying Mr. Ford, who is the one who actually took the videos, was there a police detective with you?
At Rockingham?
Yes.
Yes.
And who was that?
That was Detective Harrow.
And are you aware that the lead investigators in this case are Detectives Van Adder and Lang?
Yes.
Were they there at the location when you were there?
At that time? For the time the video was taken?
Yes.
I'm not sure.
Do you have any recollection of seeing them or not?
At that particular time?
Yes.
No.
Did Detective Harrow, who accompanied you while the videotaping was taking place, direct you to videotape blood drops on the driveway?
No.
Did he direct you to videotape a pathway along the south portion of the residence?
No.
Did the videographer basically appear to be pointing his camera at objects, including objects of value within what may be called a trophy room at the location?
Oh. Would you repeat the question, please?
Did the videographer appear to be pointing the video camera at objects within the location of, including those of value, such as the objects within the trophy room?
Yes.
So it was your understanding that this video was to be taken for purposes of potential civil liability in the future, is that correct?
That is correct.
Oral.
That is correct.
All right, anything more, Mr. Carpenter?
Did you indicate this morning to Mr. Neufeld that with regard to the 4 other crime scenes that your unit had been asked to video, that you sometimes did it where the detectives thought it would help their case? Did you indicate that?
I may have, yes.
All right. And were you asked to shoot blood drops in the foyer of the Simpson residence that day?
Not specifically, no.
Did you shoot that?
Again, I was not the cameraman, but I would say that those drops may have been in the video, but specific evidence was not to be photographed.
I see. And you were aware, were you not, that Detectives Van Atter and Lang were the co-lead investigators on the Simpson case, weren't you?
That's correct.
You knew that day, right?
I'm not sure I knew that day.
You knew it at some time shortly around that time, isn't that correct?
That's correct.
All right. And you knew that Mr. Harrow and Mr. Harper both worked in robbery homicide, did you not?
Yes.
All right. Thank you very kindly, Your Honor. That's all I have for this witness.
So let's... All right, Mr. Higgins, thank you very much, sir.
Mr. Ford, Your Honor.
Mr. Ford?
But in case you've just joined us, the jury is not present. They have been dismissed for the day, sequestered till Monday. And there has been a dispute as to a videotape that was taken by authorities during the search warrant June 13, 1994.
Mrs. Robertson?
And so Mr. Atkins, who took that videotape, was essentially voir-dired or deposed by the defense to find out what he knew, when he knew it, about the videotape, under what circumstances was it taken, the purpose for it, who had it. And in just a moment, we'll try to explain why.
Mr. Carpenter, who are you going to want after this? Who do you want?
Ford, Your Honor, I'm going to want Looper, Detective Looper.
All right, let's have Detective Looper out waiting outside.
Thank you.
All right. All right, Mr. Ford. Morning, sir. All right, would you please face the clerk?
This is another witness, the same subject, the videotape taken by prosecutors, really by the LAPD.
Yes, ma'am.
Please have a seat for witness stand. You state so your first and last names for the record.
My name is Willie Ford, Jr.
Mr. Ford, what is your occupation, sir?
Photographer for the city of Los Angeles.
And for how long have you been so employed?
13 years.
I'd like to direct your attention back to the date of June 13th, 1994. You were employed by the Los Angeles Police Department at that time as a photographer?
Yes, sir.
Did you receive a call to go to some location on that date, the afternoon hours of that date?
Yes, sir.
What time do you receive a call, sir, on that particular date?
I don't know the exact call, but it was afternoon.
All right, did you
Sometime afternoon.
we had occasion to speak with you earlier this morning, is that correct?
Yes, sir.
And at that time, did you indicate to us that you believed you received the call somewhere around 1:30?
Yes, I did.
And after you received this call, were you asked to go to some location?
Yes, sir.
And where was that?
On Rockingham.
Okay, and that's in Brentwood area?
Yes, sir.
And did you go to the Brentwood area accompanied by some individual?
Yes, sir.
Who was that?
That was my boss, David Atkins.
The man who just preceded you, understand?
Yes, sir.
All right. And did you have some instructions when going to the Brentwood residence on Rockingham?
Yes, sir.
What were your instructions, sir?
To photograph Mr. Simpson's property, any and everything, from his cars, lawn furniture, to pictures on the wall.
You were to photograph everything you saw, is that correct?
Everything.
And by the way, who gave you those instructions?
I don't know the exact names.
Well,
the detective's in charge of the scene.
Okay. The detective's in charge of the scene?
Yes.
Would the name Detective Harper
Yes.
See one of those individuals?
Yes, sir.
Is that an African-American officer?
I don't know.
All right, what about Detective Haro, H-A-R-O? Is he one of the ones?
Yes, sir.
Who talked to you? All right, and your instructions were that you were to shoot any and everything on the Simpson residence, is that
Yes,
right?
sir.
Is that right?
Yes, sir.
And what time did you arrive at the Simpson residence, again, your best recollection?
Approximately about 2 o'clock, I think, 2 or 3 o'clock.
Okay, somewhere about 2 o'clock or thereafterwards. And when you arrived there, did you follow these instructions and start to shoot the video?
Yes, sir.
And how long were you there? If you got there around 2 o'clock, how long were you at the residence?
I would say approximately an hour and a half.
So if you got there at 2, you'd be finished somewhere around 3:30 or thereabouts?
Yes, sir.
And were you using an RCA camcorder of some kind?
Yes, sir.
And the tape that you were shooting, how long could you shoot without changing the tape?
I didn't change tapes at all.
So the video that we're talking about here was shot all on one tape?
Yes, sir.
Is that correct? And you've had occasion now to see that tape since you shot it. How much tape is there?
Approximately 20 to 30 minutes
All right. So you got this 20 or 30 minutes of tape over a period of about an hour and a half, is that correct?
Yes, sir.
All right. Now, did you start off by shooting outside?
Yes, sir.
And what did you shoot outside?
Started with the Bronco, panned over to the driveway that's on the Rockingham side, and proceeded to photograph the cars and the yard, front of the house.
What about the house?
Front of the house.
All right. Did you go on the other side, the south side of the house?
Yes, sir. No, not the south side. It would be the north side.
On the north side of the house?
Facing the house would be the north side.
Did Detective Harper tell you to shoot both the north and south and each side of the house?
No, sir.
So you shot the north side?
Yes, sir.
You shoot on the other side?
No, because from my point of view, it was just the house butted up against the fence.
All right, you didn't go down the south side of the residence?
No, sir.
All right. No one asked you to do that?
No.
All right, and how long of this 20 minutes did you spend shooting outside?
I would estimate about 20 minutes.
No. How long? I thought that the entire thing was 20 to 30 minutes, so 20 minutes of that was outside?
Yes, sir.
Okay.
This is not continuous running.
Okay. And you would shoot, cut off, go to some other location, is that what is right?
Roger.
Okay, sir. Now, while you were shooting outside, were you being directed what to shoot by one of these detectives who were there?
In the beginning, I was directed to shoot, and then I was basically left on my own until I finished completing all the outside, and then I would come inside and get further instructions.
Can you give us the name of the officer who was directing you at the beginning, sir?
It was the African-American officer. I don't know which name he is.
Let's call him Harper.
Harper? Okay.
Yes. All right, and so he told you what to shoot, and then he let you go on your own, is that right?
Right.
Was Mr. Atkins anywhere near there at that point?
At some points.
Now, with regard to prior shoots, had you had occasion to ever shoot any of the crime scene before this date of June 13th?
Yes, sir.
When was that in relation to June 13th?
I would say approximately 3 months earlier.
And was that a training session for you?
Yes, sir.
And you've been trained at the earlier situation, is that correct?
Yes, sir.
This is the first time you did it on your own?
This is the first time that it was done by the request of the detective.
Okay, on your own?
Yes, sir.
All right. Now, after you concluded shooting the exterior, you had occasion to go inside, is that correct?
Yes, sir.
And once inside, were you directed what to shoot by a particular detective?
Yes, sir.
And was that Harper or was that another detective?
Another detective.
Is the name Haro, H-A-R-O?
I think so.
Similar? And what did Mr. Haro or Detective Haro tell you with regard to what you should shoot?
To photograph everything inside of the house, including pictures on the wall.
Did you try to do that?
Yes, sir.
And that took up the balance of what we now see on the tape, is that correct?
Yes, sir.
And you would shoot and then cut off and move to other locations, is that
yes,
correct?
Yes, sir.
But did you try to recover, did you try to shoot everything that appeared out in the open?
Yes.
So you'd have a complete record?
Yes.
Okay. And what was your understanding as to why you were doing this?
Just in case there were some items of Mr. Simpson's that was very valuable missing, LAPD wouldn't be accused of taking anything.
You wanted to You wanted to make a complete record, is that correct?
Yes, sir.
Do you know whether or not the officers there, the detectives there, were still searching at the time you were doing the shooting?
I'm aware that they were doing some type of ongoing investigation. I wasn't really paying attention.
Right. You don't know if you didn't see anybody searching through doors while you were there,
No.
did you? All right. So you did your shoot, and by the way, I want to very briefly, Your Honor, if I can, ask to show Mr. Ford a portion of the video at the appropriate time.
Yes.
Thank you. Mr. Ford, let me skip ahead for a moment. After you finished and concluded this video, what'd you do with it next?
We took it back to the photo lab at Parker Center.
And when you say we, you mean you and Mr. Atkins?
Yes, sir.
And what'd you do with it that date on June 13th?
Mr. Atkins told me he locked it up in the confidential file in his office.
All right. Did you have occasion to give that video tape to someone on June 14th, 1994?
Yes.
And who was that?
I think it was Detective Harrell.
Right. Was it Harrell or Looper?
I think it was Harrell.
I think it was Harrell. The man who gave you the instructions the day before?
Yes.
All right. And where'd you give it to him? Where'd you give him the
Down on the 3rd floor, Parker Center, robbery homicide.
All right. Was that the last time you saw that tape?
Yes, sir.
And between June 14th, 1994 and today, had you ever had physical possession of that tape from that time?
No, sir.
You gave him one tape, one copy?
One copy.
All right, now, with regard to the things that you were to shoot inside the residence, I'd like to just show two brief things and ask him a question, Your Honor, if I might. Can you see the video there?
Yes, sir.
And this is being shot by you, is that correct?
Yes, sir.
By the way, there was, well, I'll get to a particular point and ask you a question. Now, right there, you see that, did you shoot that glove there by a picture of a young lady there?
Yes, sir.
Was that glove placed there before you got there?
I don't know if it was placed, it was there.
All right, can you back it up?
Your Honor, for reference purposes, could we note that the time displayed on the video is 2:50 when it was seen?
Yes.
It says 2:50 p.m., 6/13/94, and we stop it there. That is the way a glove appeared there with the photograph of the young lady at the time you shot it. Is that correct?
Yes, sir.
Did anybody tell you to shoot that?
No, sir.
All right, that was just out there in that condition?
Yes, sir.
Now, with regard to this RCA camera that you had, it had a viewfinder in which you could look and see the time that you were actually shooting. Isn't that correct?
Yes, sir.
And the date?
Exactly.
So you could look and you see there was 2:50 p.m. on June 13th. Is that right?
Yes.
All right. All right, we're going to fast forward. When you were shooting the glove, was the detective with you at that point?
He might have been, I don't know.
Do you recall him saying anything to you as you were shooting that glove?
No.
You don't recall him saying "Sheehan" on the glove at all? You don't recall?
No.
All right. We'll find this other portion in just a second. Keep asking questions while you're doing that at the same time, Your Honor. All right. Now, this, you described for us that this tape that you shot was given to somebody at robbery homicide on the 3rd floor of the LAPD on June 14th. Is that right?
Yes, sir.
And then when's the first time you saw this videotape?
This morning.
And where'd you see it?
At robbery homicide.
Before you came over to court today?
Yes, sir.
All right. And who else was present while you were looking at the videotape?
I think Detective Harrell and my OIC David Atkins, and I don't recall anybody else.
And that was all this morning at what time?
Approximately 7:30, 8 o'clock.
All right. You also shot, you went upstairs in the interior of the residence and you shot photographs or a video of the bedroom of Mr. Simpson. Is that correct?
Yes, sir.
And in doing that, did you make an effort to shoot everything that was out there in and around that bedroom area?
Yes, sir.
You shot what was on the bed, right?
Yes.
Shot what was on the floor, if anything?
Yes.
All right, and so you tried to give a complete record again of shooting any and everything. Is that correct?
Yes, sir.
All right. So I want to show you some video if I can. All right, this is the bedroom area. Is that correct? Do you recall that?
Yes.
As best you can recall, you're shooting at 3:13 p.m. on June 13th in the bedroom, right?
I understand the time is off about an hour.
I'm asking you what your understanding was at that time. 3:13 p.m.?
I paid no attention to the time. I was too busy concentrating on getting the images.
But you see the time, 3:13 p.m.?
Oh, yes, sir.
You see that time? Now you shot what was on the bed there, is that correct?
Yes.
These things were out in the fashion we see them there in that photograph there at 3:14
Yes, sir.
p.m.? You went inside his closet and shot there also, right?
Yes, sir.
Shoot any luggage in that particular closet, do you recall?
In viewing the tape this morning, I think I did see some luggage.
Those weapons there, were they taken out from, were they in that condition out there like that when you got there?
Everything I videotaped was out already.
You know who moved it out there?
No, sir.
Was Haro still with you at this point, or one of the detectives with you at this point?
No, I'm by myself at this point.
You're on your own?
Yes, sir.
Shooting any and everything?
Yes, sir.
Like I saw you in the mirror there. You see yourself?
I missed that one.
All right, let me back up just a moment. With regard to the, in the bedroom area, do you see a rug of some kind in the bedroom area before the fireplace there that day?
Okay, you're talking about that fireplace to the right there?
No, I'll point it out to you, sir. Go for it.
Excuse me, I don't have any further questioning along these lines. The court, Mr. Cochran asked leave of the court to ask a couple of questions about the videotape. This appears to be a fishing expedition by Mr. Cochran with this witness on the stand. There's no need to take up this court's valuable time with this type of questioning.
Over. I want to stop there. Did you see, oh boy, back up frame or two. 313. You see that carpet? Back up. See that carpet there, the 3:13 p.m. kind of at the foot of the bed? Can you see
Yes,
that?
sir. Mm-hmm.
You take a photograph of that carpet that day?
Just what you see there.
And so just what we see there is what you saw, is that correct?
Yes, sir.
You didn't see anything unusual at that point, did you?
No, sir.
And you tried to capture everything that was out there that was anything, right?
Exactly.
So what we see here with regard to the carpet, we'll back it up and let you see it, is what you saw that day, is that right?
Yes, sir.
All right, back it up and then move forward.
Mr. Cochran, in presenting this to me, bear in mind I've seen this thing completely end-to-end 5 times now.
5 times now, yeah. Okay, well, I will bear that in mind and move right ahead. Just want to conclude at this point.
All right.
I know you're a quick study, so no problem. Okay, move forward now, move forward. So you pick up everything that you see there on the carpet at that time, is that right, sir?
Yes, sir.
All right. You tried to show everything, all right? Is that right?
Yes, sir.
Thank you, Mr. Harris. Now, you started to say something, and with regard to the time, when was the first time anyone told you that the time of the tape might be off? Was that today?
No, that was, I think about 2 days ago.
And who told you that?
My OIC, David Atkins.
David Atkins? And you hadn't seen the tape at that point, had you?
No, sir.
So that we're clear, however, you got the call about 1:30, got out there sometime around 2 o'clock, is that right?
No.
That's
Sustained.
You got out there at what time?
According to the sign-in log, it was around a little bit after 3.
Well, did you say earlier you got there between 2 and 3, sir?
You asked me what time that I thought that I got there.
Yes.
That's the time I thought I got there.
Between 2 and 3, right?
Yeah.
All right, and you then proceeded to shoot for an hour and a half at most, is that right?
Yes, sir.
All right. And so that would comport with the times you saw in that video. Is that correct? That you were shooting sometime after 3 o'clock? Isn't that correct?
Yes.
Overruled.
All right. Comports with the times you saw, right?
Yes.
You never tried to change the time that particular day, did you?
No, sir.
All right. Thank you very kindly. I have nothing further this witness, Your Honor.
Ms. Lewis?
Just briefly, Your Honor, Mr. Ford, when was the first time that anyone asked you about what was recorded or why you recorded that videotape on that occasion?
About 2 days ago.
So it's been some 8 months, 8.5 months now since you'd had occasion to even think about having taken that videotape back last June?
Yes, ma'am.
And your estimation of the time that you took...
Have it quiet in the courtroom, please.
Your estimation of the time that you arrived and that you took particular things shown on the videotape is just based on your best recollection now 8.5 months later, is that correct?
Yes, ma'am.
And you indicated you did not pay attention to the time on the camera itself, is that right?
Exactly.
So you really can't say with certainty any time that you took any particular aspect shown on that videotape, can you?
No.
Nothing further.
This, with regard to the time aspect, sir, you're aware that this was an important video to document what was going on, isn't that correct?
Yes.
And you were doing the best you could, is that correct?
Yes.
You shoot any and everything, right?
Yes.
And if you had seen or were aware the time was off, you could have changed that or corrected it, isn't that correct? Isn't that correct?
I would say yes if it was of some concern, yes.
Yes. All right. Thank you very kindly. Detective Looper, Your Honor.
Ms. Lewis, anything more?
May I have just a couple of questions outside the scope of my initial cross, just briefly?
Briefly.
Did any detective or anyone else direct you to take photographs, or videotapes, I should say, of blood drops in the driveway at Rockingham?
No.
Did anyone ask you to video the pathway that runs between where the house butts up against the fence on the south side? Did anyone indicate to you that this was going to be used by the district attorneys in the case?
No.
And was your understanding that this was taken to document the valuable items that you saw throughout the house?
It's cross-examination.
Well,
I'll allow the question.
And was it your understanding that your purpose in taking this videotape was to document the valuable items that you saw throughout the house, including the Heisman Trophy and other items of value, so that the Los Angeles Police Department would have that on record as having existed then in case of a later lawsuit? Was that your understanding?
Testify.
Was that your understanding, sir?
Yes.
Thank you.
And when you took that picture of that glove there, you thought that was a valuable object, did you?
Counsel, I saw what was on the table there.
All right, well, all right, very well.
It looked like a Tiffany-style lamp and a few
Well, there
other
was also, he zoomed in on the glove, obviously.
Just for the record, did you notice that there were valuable items on that table, like a lamp or so forth, in addition to the glove?
Ms. Lewis, you should also bear in mind that I've seen this 5 times.
Just for the record, Your Honor, thank you.
One last question, Your Honor. Did you shoot some reported blood drops in the foyer area of the residence?
Yes.
Somebody told you to do that?
No.
You just did it on your own?
Yes.
Again, shooting everything you saw, right?
Yes.
Okay. And you, with regard to the purpose, your purpose for being there, you've told us your purpose was to shoot any and everything at the direction of the detectives who told you to do this, right?
Yes.
All right. Thank you, sir. All right. Looper, Your Honor.
Detective Looper, thank you very much.
Okay.
Well, again, the jury is not present. They've been sent home. 3 witnesses, this next one, to take the stand. involved in the taking of this videotape June 13th at O.J. Simpson's home for the purpose of making sure that nothing ended up missing during the course of a search and seizure, and that the LAPD wouldn't be blamed. But the defense wants to use this videotape to show something else.
Yes. My name is Adalberto Luper. First name is spelled A-D-A-L-B-E-R-T-O. Last name is L-U-P-E-R.
Good morning, good afternoon now, Detective Luper.
Good afternoon, sir.
You are one of the investigating officers assigned to this case, are you not?
Oh, well. Yes, sir.
And in that connection, back in June, on or about June 13th, 1994, were you one of the officers or detectives from robbery homicide assigned to the Simpson case?
Yes, sir.
Did you at some point on or about June 14th receive a videotape that was shot of the Rockingham residence, sir?
Yes, I did.
What time on the 14th did you receive such a tape?
It was in the morning sometime. I don't recall the specific time.
Your Honor, at some point I should mark this tape. It's over there now, so we'll reserve a number so I don't forget to mark it. And as defendant
1068.
Defendant's 1068. You received, and you've seen the tape this morning, have you not?
Yes, sir.
Okay, it's about a 20, 30-minute tape. Defendant's 1068. You received.
Oh,
Chrissy.
You received this tape sometime on the 14th in the early morning hours.
That's correct. It was in the morning, yes, sir.
Do you remember about what time it was?
It have to be anywhere between 8 and 10, somewhere in that.
And from whom did you receive this tape?
I received it from, I believe it was Detective Harrell.
From Harrell? Yeah. And where were you when you received the tape from Harrell?
I was at Parker Center, room 321, at my desk.
And when you received it in room 321 at Parker Center on June 14th, in the early morning hours or between 8 and 10, what'd you do with the tape at that point?
I went upstairs to the electronics section and asked to be able to use their VCR and monitor to view the tape.
And did you view the tape at that point?
Yes, sir, I did.
So you saw it on the 14th?
Yes, sir.
It's the same tape we now have here today?
That's correct, yes, sir.
And did you view it by yourself or with someone else?
By myself.
All right. After you viewed the tape, what'd you do with it at that point?
I returned down to my office because I was charged with having to write the employee report of the search warrant, and I was informed that it wasn't necessary because the captain had been there and the employee report would have been submitted to him.
Captain Gardlin we're talking about?
Yes, sir.
And so you did not write an employee report about this item?
That's correct, sir. I did not.
All right. You then you had possession of the tape, Defendant's 1068. You had seen it by now. Did you write any reports at all at that point?
No, sir.
You then did something with that tape?
Yes, sir.
And what was that?
I put it in my desk drawer.
Okay, now at this point, this was your regular desk drawer?
Yes, sir.
Okay. Now, did you ever take that tape up or put it in the so-called Simpson War Room at Parker Center?
Yes, sir.
When was that?
That was probably 3-4 months later.
All right. So at first you put it in your desk, is that correct?
Yes, sir.
And about how long would you say it stayed in your desk?
About 3 or 4 months.
And then you had occasion, there was a Simpson War Room developed, and then that's also in Parker Center?
Yes, sir.
And then you had occasion to move it from your desk?
Yes, sir.
When was that approximately?
It would have been around the same time, 3 or 4 months after the video was taken, along with several books that I had.
So it would be July, well, strike that. It would be about September, October?
Yeah, roughly September, October, yes, sir.
Again, do you have any reports about the time it was moved from your desk to the war room area?
No, sir.
All right. But it remained in police custody at that point also?
Yes, sir. It was locked up in a file cabinet.
And by that time, when it was moved to the location in the war room, the preliminary hearing had taken place, is that correct?
Yes, sir.
And by that time, if you recall, had we started picking the jury in this case?
I really don't know, sir.
All right. If it was in October, you were aware of the proceedings that took place here?
I'm aware of the proceedings, yes, sir. But as to the chronology, no, sir.
All right. So you don't know whether it was during pretrial or we started picking a jury at that point?
That's correct, sir.
But you can tell us within 3 or 4 months of the time you first received it on June 14th, after it was in your desk, it was then moved to a file cabinet in the war room at Parker Center. Is that correct?
That's correct, yes, sir.
Now, at some point, you had occasion to tell someone you had this tape, isn't that correct?
Yes, sir.
And did that coincide with some testimony of Detective Lang with regard to the location of objects inside the Simpson garage there at Rockingham?
Oh, well. No, sir, it had nothing to do with any testimony.
You just remember that you had this tape at some point?
It was brought to my attention that it was possible that I was going to testify to the execution of the search warrant.
All right.
And during my research of that, photographs, etc., I remembered that we did have a videotape.
Now, with regard to this video, there were a number of officers out there on the date that video was shot, right? Correct?
There were several patrol officers. I believe there was maybe 7 detectives, 4 from robbery homicide, 3 from West LA, and I believe Mr. Fung and Ms. Mazzola, and I think the print people had already left.
Just so we're clear, you were there, right?
Yes, sir.
All right. And was it your understanding that this video was shot during the execution of the search warrant, or had all items been recovered by that time?
All the items within the residence had been recovered at that time. I knew that there was some presumptive tests that we were still doing, but as far as I was concerned, all the evidence had been recovered, yes, sir.
All been recovered, except for maybe some presumptive tests, right?
That's correct, yes, sir.
All right. And just quickly for us, can you give us the names of the detectives from robbery homicide who were present during the taking of this, shooting of this video?
It would have been Detective Haro, H-A-R-O, Detective Harper, H-A-R-P-E-R, my partner, Detective LaFall, L-E-F-A-L-L, myself, and possibly Detective Roberts, and that's the only ones that come to mind right now, sir.
All right, and you mentioned something from West LA. Anybody from West LA you recall?
That would have been Detective Roberts from West LA. I would have to check the crime scene log to be sure.
All right. Now, at some point, you were told that you might have to testify in connection with the search warrant?
That's right.
In this particular case here?
Yes, sir.
You didn't testify in any of the pretrial motions, did you?
No, sir.
All right. And when were you told that, and by whom?
I was told that the last week of February of this year, and I believe it was Detective Van Adder who informed me of that.
So in February, Van Adder told you you might have to testify in connection with the search warrant?
That's correct, yes, sir.
And then you started looking at photographs and videos, and you discovered this tape, right?
Looking at photos, yes, no video, but I realized we had a video at that time, yes.
All right. And when did you bring the fact to the attention of the district attorney's office that you had this video?
That was either March 22nd or March 23rd of this year, sir.
So even though you knew you discovered it yourself back in February?
No, I believe it was probably a week or two after that that I discovered it.
So maybe the first part of March?
Yeah, within the first 2 weeks of March, yes, sir.
All right, and you told the district attorney's office about this, or some representative, on or about March 22nd?
That's correct, yes, sir.
Who was told?
Detective Tom Lang was told, at which time we made a notification to the city attorney's office, and then it was then subsequently turned over to the district attorney's office.
Who in the city attorney's office did you talk to?
I don't recall the name, sir. I didn't make the call.
Right. That would have been in the first week or so of March?
No, that would have been on March 22nd, right, or the 23rd.
But when you first discovered it during the first week of March, who in the robbery homicide division did you talk to about this?
Nobody.
You didn't tell anybody at first?
No.
All right. And when was the first time you told somebody in robbery homicide?
It was either, it had to either be March 22nd or the 23rd, because that was the first time that it was brought up by myself.
And who'd you tell at that point?
Detective Lane.
So any particular reason you didn't tell anybody between the time you discovered the first week of March and March 22nd, 23rd?
No particular reason other than that I didn't at that time feel that it was something that they needed to know because of the reasons it was being held initially.
I see. And what was your understanding for why this tape was shot originally?
It was shot strictly for administrative purposes to record the valuable items in Mr. Simpson's residence and to prevent any civil liability that might arise in the future.
Was there a city attorney on the premises on the date it was shot?
No, sir.
And when you saw that tape, you saw, however, strike that. Were you aware that the man who shot the tape had received instructions to shoot every and anything inside the residence and most of the exterior? Were you aware of that?
My understanding of the instructions were that he was to film the valuables in the residence and to do a cursory filming of the exterior. Yes, sir.
Did you, in watching the tape, did you see the glove on the table that was zoomed in
yes,
on?
sir.
You didn't consider that one of the valuables, did you?
No.
All right, Mr. Cochran, we're going to need to break here.
Can we approach this a second? Well, we can approach.
Well, what I anticipate doing at this point, breaking here, I have a 1:30 calendar. I have a white-collar sentencing hearing with 4 defendants at 1:30. Okay. So I anticipate recessing this now and reconvening at 8:30 on Monday.
Okay. All right, that's fine.
All right. Detective Looper, I'm going to order you to return Monday morning, 8:30. Don't discuss your testimony with anybody except for the lawyers on each side.
Yes,
All
Your
right,
Honor.
see you Monday morning. All right, who's the other witness, Mr. Cochran? Mr. Cochran, who's the next witness?
Detective Harper, Your Honor. He'll be the last one.
Harper?
Detective Harper. We've also heard Detective Harper was there. Other detectives were there.
He's one of the individuals who was there apparently giving instructions as to what to do, was there for the service of the search warrant. I assume there's something there.
I don't share in Your Honor's faith in making that assumption.
Well, just have Detective Harper here. All right. As to this case, we're in recess until 8:30 a.m. Monday. All right, we'll reconvene court at 1:30 on the sentencing matter.
Back when the search warrant was conducted in June of 1994 at O.J. Simpson's estate, as a matter of course, the LAPD videotaped it. They do that to make sure that they're not accused later on and sued of stealing certain items or leaving the home in such disarray that it's caused damage to the premises. They do that because they've been sued several times over just such a thing. The defense first learned about this videotape, however, quite recently. And they feel, first of all, that it's valuable to help them in their defense of O.J. Simpson to show that some things were going on that shouldn't have been during that search and seizure at his home. And second of all, they're sort of asking the judge to sanction or punish prosecutors because it hadn't been handed over earlier. Why all of these witnesses? Perhaps only the last witness was important and a handful of questions relevant. Where's the tape been? When was it that you first realized recently that, in fact, you had this tape? Why didn't you realize it was important earlier? And when did you notify prosecutors that you had in your possession this videotape? It really comes down to, Michelle Levine, and you're a prosecutor, to a handful of questions, and yet it took the better part, as I look at my watch, of about 45, 50 minutes to get right down to it.
It's puzzling to me why Judge Ito is not narrowing the parameters of this type of a hearing. It's fairly clear that the prosecutors turned over this evidence as soon as it was given to them. So the issue is no longer hiding anything or whether or not it's been turned over. The issue is exactly as you have outlined it, is when was it turned over, when was it known, and should there be sanctions? And it seems to me that only this last witness was relevant to those issues in terms of the question. But Judge Ito seems to be allowing the defense to go far afield from the issue really that's being litigated.
Although I will say on behalf of the defense, first of all, if this is done as a matter of course, why didn't prosecutors know that? And they should have. And if they do realize that it's done as a matter of course, then why didn't they long ago say, you know what, in fairness, here's everything we have, including a videotape, because we always videotape searches and seizures.
I don't think that's correct, though. It seems to me that what the prosecutors have been saying is and what the detectives have been saying is this is not always done as a matter of course. It's done in certain instances. It was done here because, as you indicated, there have been situations where lawsuits are filed about missing objects or that objects have been damaged in the course of doing a search. And so that was the purpose of this. Whether or not that was known to prosecutors and when it became known to prosecutors might be an issue. But that seems to be very narrowed, and certainly that's not what we saw late this morning and into the afternoon.
Well, I wouldn't have guessed it, but maybe we'll see a prosecutor on the witness stand answering those questions. It seems Judge Lancito is providing counsel for the defense wide latitude in this. Michelle Levine, it's been a long morning. We appreciate your being here from the beginning to help sort of explain the intricacies of the law and procedure. Come back soon if you would.
Thank you very much.
Let's go back to Ricky Kleeman in New York. Ricky, what's ahead?
We are going to take a look at some highlights from the testimony of today, Greg, and I hope you have time to get some lunch because we'll be back to you in about an hour. Right now, we are going to take a commercial break. We'll come back with some tape, and later we'll get to talk to you. Although it was anticipated that we were going to be in the world of criminal lists and forensic evidence, and perhaps even seeing something like a garbage can from the airport or hearing from mystery witnesses who may or may not have seen Mr. Simpson doing something with his luggage around a trash can, what ultimately happened today in court was we heard from someone else. We heard from a neighbor, a man by the name of Charles Cale. He's a neighbor of O.J. Simpson's. That is, we're talking about the Rockingham address. And apparently Mr. Cale has to tell the jury that he says between 9:30 and 9:45 that evening that the Bronco was not on the street. So let's see what he said during direct examination.
And directing your attention to the morning following the murders of Ron Goldman and Nicole Brown. And this will be Monday, June 13, 1994. On that date, at approximately 7 o'clock in the morning, were you on Rockingham?
Yes, sir, I was.
Okay. Were you in a car?
Yes, sir.
Were you alone?
No, I was having somebody drive with me to the airport to take my car back home.
Okay, so you were en route to the airport?
Correct.
Okay. And on that date, Monday, June 13, at 7 a.m. in the morning, did you drive down Rockingham?
Yes, sir.
Okay. And did you pass the defendant's residence at 360 North Rockingham?
Yes, sir.
Now, from which direction were you driving?
I was driving from north to south.
Okay. So you were, just right there. And as you approached the defendant's residence, did you have to pass through the intersection at Ashford?
Yes, sir.
And did you pass through that intersection?
Yes, sir.
Okay. Now, you've been at that intersection before, at Rockingham and Ashford, is that right?
That's correct.
Okay. And I take it that you passed through the intersection on your way down to Sunset Boulevard?
That is correct. That's.
And is there a path or a course that you usually take as you drive down to Sunset?
Yes, sir. There is.
Do you usually pass through the intersection at Rockingham?
Usually I would turn left if I were going to be going east on Sunset to go across to Cliffwood, and turn left at Cliffwood because there's a light. And you can't turn left onto Sunset from Rockingham. If you're going down that way, there's no left turn sign.
Okay. Now, do I understand you to say that you would usually turn left at Ashford?
Yes, sir.
Okay. Did you turn left at Ashford that Monday morning?
No, sir.
And why not?
Because I saw a black and white patrol car, police car, parked in the street, just east of Rockingham on Ashford, between the corner and the gate in the entrance into Mr. Simpson's home on Ashford.
So you couldn't turn left?
Could have turned left and gone around, but it would have been, we had to go out of the way or off into the left lane.
Okay. And so did you continue then south on Rockingham?
Yes, sir, we did.
Did you pass the defendant's gate, the gate to his residence at 360 North Rockingham?
Yes, sir, I did.
And as you did so, did you notice a vehicle at all?
I did. I noticed the white Ford Bronco.
And where was the white Ford Bronco when you first saw it that Monday morning?
It was just to the north of the driveway, the Rockingham driveway, parked at kind of a strange angle with the rear out from the curb a little bit more than normal.
And did you pay particular attention to the Bronco?
Yes, sir. I was surprised to see it, and so I noticed it.
Okay. Why were you surprised to see the Bronco at that time?
Well, very seldom, if ever, had it been parked there. In fact, seldom, if ever, were any cars parked on the Rockingham side of the street as I went along from the past. And I noticed that. I noticed that it was parked at sort of a strange angle. I mean, you could tell it was out. The rear wheels were out a little bit. And also, I had not noticed it the prior evening.
You had not noticed the Bronco parked on Rockingham the prior evening?
That is correct.
Okay. Were you outside the prior evening?
Yes, sir.
Okay. This would be Monday, or rather Sunday night, June 12th.
Sunday evening, June 12th.
And why were you out Sunday evening, June 12th?
Well, I had taken my dog for a walk. I had been packing to get ready to go to the trip early the next morning. And I took the dog out for a short walk and had been walking on Rockingham. And when I was walking, I hadn't seen the Bronco.
Okay. Now, what time was it, if you recall, that you walked your dog Sunday evening?
About 9:30, 9:45 period.
And so during this time period of 9:30 to 9:45, you say you didn't see the Bronco on Rockingham?
Yes, sir. I did not see the Bronco on Rockingham.
Okay. Now,
today, after this witness, Mr. Kale, testified, there was a hearing outside the presence of the jury, and it had to do with the subject of police photography and videotape concerning the actions of the police and the search that happened as of June 13th, 1994. We're going live now to Los Angeles and to our reporter, Dan Abrams. Dan, why was there this hearing today?
Well, Ricky, there was a lot of confusion about the scope of this hearing. This was a discovery hearing. The defense was alleging they didn't turn it over fast enough. They took this tape back in June, on June 13th of 1994. We didn't get this tape until March 24th. So there were a lot of questions about exactly when the tape was turned over and to whom it was turned over. Now, an interesting point is that it is the prosecution who wants to introduce this tape. They want to introduce it during Dennis Fung, the criminalist's testimony. Dennis Fung is expected to be the next witness. And because they want to introduce it through Dennis Fung, we have to have this hearing now, before Dennis Fung takes the stand. And so one of the sanctions that the defense is going to request is that they not be allowed to use this tape during Dennis Fung's testimony. That's why we need to have the hearing now. It doesn't answer the question, of course, why the scope of the questions has been so wide. Why have there been so many questions about why they were taking pictures of what they were? And prosecutors were clearly frustrated as they walked out of the courtroom because they didn't have the answer to that question. They said they didn't understand it, that this was a discovery motion, and it was unclear why so many questions were being asked and why these witnesses were all being called.
Well, it was a mystery to us back here, too, not only in terms of the wide latitude, but ultimately it's a mystery, at least to me, as to what the whole thing means. Have you got an answer for that, Dan?
Well, what it means is the defense wants to say you shouldn't be able to introduce this tape because you turned it over to us so late. That should be the punishment. And in the past, Judge Ito has entertained arguments similar to that. In the end, though, he has usually just forced a delay, meaning he might not allow the prosecution to introduce this tape at the beginning of Dennis Fung's testimony, to afford the defense an opportunity to truly scrutinize it. Maybe say to them, well, you can't introduce it until the end of Dennis Fung's testimony, or maybe they could even force them to recall Dennis Fung. Of course, the most severe sanction would be to say, you simply cannot introduce it. And the real question that Judge Ito will have to decide is, was it willful? Was it done on purpose? Did they intentionally try and keep it from the defense? And the prosecution is trying to show here that the police didn't even find it until the beginning of March, that they then recovered it in the process of preparing for testimony on another subject, that they then turned it over to the prosecution on March 22nd, and the prosecution then immediately turned it over to the defense. Well, we'll have to see whether or not Judge Ito feels that that is so reckless such that he would grant the defense's request to keep that tape out altogether.
Well, it certainly changed the course of how this day was going to go, at least from what we expected. So, Dan, do you have any idea what we should expect for Monday?
Well, Monday morning at 8:30, we're going to continue with this hearing with some of the other detectives who were present when this videotape was taken being called. And as soon as Judge Ito resolves this issue, prosecutors intend to call Dennis Fung to the stand. Now, as we've seen in this case, that is always subject to change. Prosecutors could decide to present another witness before Dennis Fung. But we've seen that Judge Ito's made it very clear that in his mind, there's a separation, a division in the prosecution's case. We're now moving to the evidence collection phase of the prosecution's case, so it would probably be unlikely that they would call anyone not in the evidence collection phase. So expect to see Dennis Fung on the stand on Monday, and expect to see a new prosecutor, Hank Goldberg, who's been involved in this case throughout, but hasn't questioned any witnesses so far, questioning Dennis Fung.
Thanks so much, Dan. And I'm sure we'll hear from you sometime later, and of course again on Primetime Justice. What we're going to do right now is we are going to take a commercial break. When we come back, we're going to have more of the neighbor's testimony. That's Charles Cale. We're going to move on toward the cross-examination.
I'm Beth Karras with a Court TV docket report. Join us tonight at 10 p.m. Eastern and Pacific Time for Washington Watch. This week, anchor Fred Graham and his guests will look at the Senate's attempt to curb online obscenity. Will preventive measures violate the First Amendment? Also, an interview with the man conducting the Clinton administration's review of affirmative action policies. And a discussion about a court challenge to the Brady gun law. That's on Washington Watch tonight at 10 p.m. Eastern and Pacific Time. And join us Monday at 9 a.m. Eastern Time for a New York trial in which a homeless man is charged with the murder and attempted robbery of a former Rockette dancer. Alexis Welsh was walking her dogs at 5:30 in the morning in June of 1991 when she was allegedly stabbed by Kevin McKeever. McKeever, who has a long history of mental illness, denies any involvement in the killing. That's New York versus McKeever, Monday at 9 a.m. Eastern Time. That's the Court TV docket report. I'm Beth Karras.
Our guest commentator for this segment of the day is Bobby Sternheim. Bobby has been with us before, and particularly in this segment, so it's great to have you back.
Thank you.
I always enjoy seeing you, Bobby.
It's nice to be here again.
Bobby is a lawyer, been practicing some 15 years, now a defense attorney in New York City, but you have a history in the past. You were a prosecutor in Brooklyn, and you still teach as an adjunct professor and teach trial advocacy at Cardozo.
That's right.
So you have a sense of what happens definitely on both sides. And
I hope so.
I know you do, and we'll have some time to talk with the viewers later. But I want to clear up something about the hearing that we had heard before we came to New York, when I just talked to Dan Abrams about. This seemed to be, to me, much ado about nothing, ultimately. Because although there is this videotape, is it probative of anything? Does the prosecution really need this videotape? Does the defense really need to keep it out?
Well, without having seen the videotape, it's hard for me to answer that directly, but I would assume that it's really an aid to the jury to comprehend what was going on at the scene at the time that the people were there. I don't think it's necessarily probative of anything, but in this case, something that doesn't seem probative one day becomes probative the next. But I believe that if it is kept out, the prosecution will survive that and just go on. But pictures are always a help to the jury, and a videotape is particularly helpful because it spans just a larger range than a photograph can.
The defense really has gotten wide latitude in their questioning of these witnesses, and again it starts to look like, well, where has it been? Why don't we know about this videotape? And maybe that's the flip side of the prosecution's complaint about the defense not coming up with statements, particularly in the case of Rosa Lopez, while they were sanctioned. Is there a difference in the kind of conduct or in the result between the Rosa Lopez situation or this videotape?
Well, clearly a statement by a witness is far more probative than a videotape of a scene. This isn't even the crime scene. This is a scene where things could be retrieved or a search warrant is executed and they preserve the contents of a house for proof that nothing untoward was done at a later point. In the situation with Rosa Lopez, or any other witness for that matter, whose statement was not turned over, that directly hurts the other side because they don't have the opportunity to investigate. But I don't think that the failure to turn over something like this would result in the same kind of sanction. If it was a ministerial omission, if it's something that was routinely done, perhaps the defense might have made a more direct request for it, and I'm not sure that they did a direct request of this. I think they did a routine discovery request. In this situation, it seems to have been an oversight because the prosecution seems to not have been so aware that this existed either. It seems like it was something that was just filed away and now it's someone remembers that it's there and they bring it up. But I don't think that the two are equal at all. Certainly failure to turn over the statement of a very crucial witness, and in the Rosa Lopez case it was a witness who was going to directly support the alibi, would be far more crucial than not giving over at an earlier date a photograph or a videotape of a scene that isn't as important as the crime scene itself.
Well, we'll see how Judge Ito eventually rules. What we're going to do now is we are going to look at the cross-examination of Charles Cale. And at some point after that, and I'll let you know when, we really are going to take your calls. We're going to run this segment of the luncheon recess a little longer than usual, so we'll have plenty of time to talk with you. Mr. Cale is cross-examined this time by Robert Shapiro, and Robert Shapiro is interested in the question not of one Bronco, but of various Broncos. Let's see what happens.
Have you ever seen any other Broncos at Mr. Simpson's residence or in the area of, strike that, in the area of Rockingham and Ashford, have you ever seen any other Broncos other than Mr. Simpson's Bronco?
I've seen other Broncos, yes, sir.
And you've seen them parked in many different locations, have you not?
Seen them parked on Ashford.
Have you seen Mr. Cowlings in the area of Mr. Simpson's residence?
Yes, sir, I have.
And have you seen his Bronco parked on Rockingham?
Not that I recall. I've seen his Bronco parked on Ashford, I know.
Is there something in particular about noting where a Bronco is parked 8 months ago that is important to you?
I don't really quite understand the question, Mr. Shapiro.
Have you watched any part of this case on television, any part of this trial?
Very little.
So you've watched some of it?
Very little.
What have you watched?
I've seen news clips from the news when I watch the regular news. That's really about all.
Have you seen any witnesses testify in this case?
I've seen saw Detective Furman briefly, and I don't know the detective, I don't even know his name, was there in the gentleman sitting behind counsel. I saw...
Indicating Detective Lang.
And I probably saw 2 or 3 minutes in total of Ms. Lopez.
And you were aware that all 3 of those people gave testimony regarding the Bronco, are you not?
Sustained. Be stricken due to disregard.
I'm sorry, are you aware that Detective Furman gave information regarding the Bronco?
I really don't know what information Detective Furman gave about the Bronco, if he did.
About Detective Van Adder?
I did not see Detective Van Adder at all, even on the news that I can recall, so I don't know what he talked about.
What about Detective Lang?
I don't remember anything that he talked about. I just remember seeing him.
Can you tell one Bronco from another?
That's a question I don't know how to answer, Mr. Shapiro.
Yes or no?
I don't think that's a question that's susceptible to answering yes or no. If you have two identical Broncos, I couldn't tell which was which. I can tell you that I recognized a Bronco when I saw it.
Did you recognize it as Mr. Simpson's Bronco, or did you recognize it as a white Bronco?
I recognized it as a white Bronco.
We're going to take a break in the middle of this cross. We'll be back for the rest of the cross and later your calls. Charles Cale, a neighbor of O.J. Simpson, has testified today for the prosecution that he did not see O.J. Simpson's Bronco between 9:30 and 9:45 on June 12, 1994. He's been cross-examined by Robert Shapiro, and probably the focus of this cross-examination is whose Bronco was it anyway? Let's see what happened.
Are you aware that Paula Barbieri has a white Bronco?
No, sir, I don't know anything about Miss Barbieri other than what I just said.
You are aware that Mr. Cowlings has a white Bronco, do you?
Yes, sir, I am.
And do you know that the only way that an outsider can gain entrance to the Rockingham property, to Mr. Simpson's residence, is through the Rockingham gate?
Excuse me? Would you?
Sustain.
Is there anything in particular about the Simpson residence that causes you to focus on it?
Well, it has a...
Oh, well, you can answer the question.
Yes. Mr. Simpson is a celebrity. Certainly I think one of the most well-known people in the neighborhood. Also, it's on the corner where you either going south or, either going west or east on Sunset. If you're going to go to Sunset, you go by Mr. Simpson's house. It's distinctive. It's Christmas lighted brightly. I mean, I think it's a focal point.
Well, I'm here with Bobby Sternheim, and let me ask you this, Bobby. It starts to be this, whose Bronco is it anyway? Is it Paula's? Is it Al Cowlings? Is it Al Cowlings again? Is it O.J. Simpson's? Is the point of this to make the jury think that it might be someone else's Bronco?
I believe it is.
And if it is that helpful for the defense?
Well, anything that points away from O.J. Simpson can be helpful to the defense. I don't know how helpful it is to point to a friend or a lover. It gives the impression that he may have used their Bronco. I don't think that's particularly helpful. But anything that can shield O.J. Simpson or take the jury's view away from him is helpful to the defense.
What about this person, Charles Cale? I have not heard of him before this. I don't know that you have either. No. I assume the defense must have, because they didn't object to his coming on, so they must have had some discovery. But one wonders when he came up in this investigation. What if he came up more recently? Would you expect the defense to cross-examine him more vigorously about that?
Well, I think that they would ask, when did you first tell this to the prosecution or report it to the police, in a way to discredit that this is something that he recently contrived or information that he only now thinks is important. But perhaps when there was canvassing of the neighborhood around the time of the arrest and the investigation, that this was a witness who was earmarked as someone who potentially could give testimony about what the atmosphere was like around Rockingham on that evening.
And if that is so, and he was there at the very beginning, he is amazing in and of himself that we haven't heard about him until today.
He probably prefers it that way as well.
I would think that's true. Right now what we're going to do is we are going to take a break. We're going to come back and be able to talk to you. Both Bobby Sternheim and I are going to be happy to answer your questions if we can. And we certainly want to hear your comments about the Simpson case. The open line number is area code 212-557-1301.